meeting. And we have here in the meeting room Representative Cardone and myself and our analysts. And we have all of the other participants are available on Zoom. And so what we'll do is we're going to start with introductions from those who are participating remotely. And I'll just call folks' names down the list of appointees. And so Senator Keim, we'll start with you.
Good morning, everyone. My name is Lisa Keim, and I'm proud to represent Senate District 18, which is Northern Oxford County.
And next we have Justice Gorman.
Good morning. My name is Ellen Gorman, and I'm an Associate Justice on the Maine Supreme Judicial Court.
Thank you. Judge Martin.
Good morning. I'm John Martin. I'm a district court judge and I sit in the Rockland District Court.
Thank you. Judge Crockett.
Jared Crockett, Oxford County Probate Court.
Register heirs.
Kathleen Ayers. I'm the president of the Association of Registers of Probate and registrar from Kennebec County.
Thank you. Judge Aventaggio.
Morning, I'm William Aventaggio. I'm Judge of Probate for Lincoln County.
Thank you. Judge Mitchell.
Good morning, Libby Mitchell, Judge of Probate, Kennebec County.
Tudor Goldsmith.
Morning, everybody. I'm Tudor Goldsmith. I'm an attorney with Jensen, Baird, Gardner, and Henry. I'm here on behalf of the Maine State Bar Association.
Thank you. And Leo Delicata.
Good morning. My name is Leo Delicata. I'm an attorney with Legal Services for the Elderly.
Thank you very much. And now we're going to have the OPLA analysts who have been working so hard to assist the commission introduce themselves. And Janet, you want to start?
Hello, I'm Janet Stocco. Sorry, I had to move my computer to get the mic so you can see me. And I'm from the Office of Policy and Legal Analysis, and I ordinarily am legislative staff to the Veterans and Legal Affairs Committee.
And Sam Sennett.
Hi, sorry you can't see me very well because I'm backlit, but I'm Samuel Sennett, an OPLA analyst, and I ordinarily staff the Education and Judiciary Committee.
Thank you both. And Representative Cardone.
Hi, I'm Barbara Cardone. I am the House Representative for House District 127, part of Bangor, and I am co-chair of this commission.
And I'm Ann Carney. I represent Senate District 29, which includes South Portland, Cape Elizabeth, and some of Scarborough. And I'm the Senate co-chair of the commission and also serve as the co-chair of Judiciary Committee. And with those introductions, we'll launch into our work for the day. And we're going to start with a discussion about late votes by absent members. Just to recap briefly what happened at the last meeting, we conducted a vote on the plan. Many of us cast votes. There were some members who were absent from the meeting who, and we gave them a set amount of time until 5 o'clock the subsequent day to cast votes. And several folks did not cast votes by that deadline, but did wish to weigh in. And I didn't feel like, since we had announced it to all of the commission members at the previous meeting, that we were only going to keep the votes open for a set amount of time. I didn't feel like we could just go ahead and extend that opportunity without running it by other members of the commission. My personal feeling is that I think it's fine to accept late votes on this issue. But I also don't want to, if other commission members feel that it's important to stick to the 5 o'clock deadline, then I want to respect that as well. So I just ask commission members if anybody has strong feelings or any feelings actually that they want to express about this issue. And please either wave your real hand or your virtual hand. Yeah, I'm not seeing, oh, go ahead, Senator Keim.
Thank you. Yes, I missed the deadline by a half hour or so. And but I think if we're gonna have a final vote overall, I'm not sure that I need to have an intermediate vote recorded. If we're gonna have just a final vote, that's fine as well, which I can do today, I know. So however you would like to proceed is fine with me. Maybe there were others that wanted to vote as well. I don't know.
I also didn't vote, and I didn't vote because I've looked at the numbers and it seemed like mailing in your absentee ballot after a landslide. So again, understanding that there was more votes coming, I didn't bother.
How do you feel, Judge Avantagio, about casting a vote either now with regard to the vote we took on the 15th, or at by 5 o'clock tomorrow with regard to the vote that we anticipate taking today? Do you have do you feel like it's important for you to cast a vote vis-a-vis the November 15 issue, or are you fine just voting on today's vote?
I'm fine just voting on today's. Thank you.
Okay, so it seems like there is a non-issue here to be, so that we do not have to resolve it, because everybody's content to simply cast votes with regard to the vote that we anticipate taking today. And from a procedural perspective, I want to let people know that this is our last meeting, and we will not have any other opportunities to get together as a group. And so the vote that we are taking today, we will set an absentee voting deadline of 5 o'clock on December 1st, and we'll stick with that deadline. There won't be any extensions. So please, if you have to leave today's meeting, please make sure that you email the OPLA analyst, Sam and Janet, and then please copy Representative Cardone and myself. And so that addresses and resolves that issue. Thank you, everyone. And now we'll move on to our second agenda item, which is the plan for transitioning to the new proposed probate court system. And this is a plan that Representative Cardone and I kind of took into account all of the information that had been presented with regard to the transition plan, and we came up with a draft plan. Before we move into that, I see that Judge Mitchell has her hand up.
I will wait, assuming that you're going to say before we move into that, we can discuss all the rationale things that were distributed to the committee.
Yes, thank you very much for raising that. I had intended or envisioned discussing that with regard to when we reviewed the outline of the draft report, but I agree with you, Judge Mitchell, that it's more of a pressing matter. And so maybe what we should do is kind of flip-flop our agenda items a little bit and talk about it and have a discussion of the rationale, and then move into a discussion of the transition plan. Does that, Representative Cardone, does that seem okay to you?
That's fine. And if we could start off, I thought you. That's fine. And if you wouldn't mind if I started off saying a couple of things.
Yes, that would be terrific, but let's let Representative Sheehan, who just joined us remotely, introduce herself, and then I'll turn it over to you.
Good morning, everyone. My name is Erin Sheehan. I represent Biddeford's House District 12, and I serve on the Judiciary Committee. It's good to see everyone.
Thank you, Representative Sheehan. And Representative Cardone, the floor is yours.
Thank you. I just wanted to, as an introduction to this discussion about the long-term goals with the rationale, and this is a separate from the draft report, as you'll see. These, nothing on these, in this rationale or reasons for supporting or objecting, including the whole format of supporting reasons or objecting reasons, are even part of the draft report. I asked OPLA to put together something for our discussion purposes and our discussion purposes only. It does not mean that anything on this, any part of these reasons or rationale needs to be incorporated into the report. It's just my feeling as a discussion facilitator that it's better to have something down on paper that people can think about and talk about than not to have anything and have people trying to think about what they want to say. So this was an introduction. This was meant to be an introduction to our discussion. There's nothing on here that anybody has signed on to in any way. And I just wanted to make that clear because more than one person expressed some reservations about more than one thing that was written on this draft. So if that's clear to everyone, we can feel free to discuss in whatever order you want, keep them, scrap them, completely rewrite them. I just wanted to make clear to everyone what this was and what it wasn't.
Thank you, Representative Cardone. I'd like to have input and discussion from any members of the commission who want to react to Representative Cardone's description of the rationale document, or if anybody has any feedback or comments about the rationale document. Go ahead, Judge Mitchell.
Thank you very much. I did send an email to the commission so that they understood before today that I had concerns about those. I very much respect what Representative Cardone has said. They're not part of the report. However, they bleed into the report, and I think it's really important that we at least discuss them. And if we're going to go forward, I mean, we obviously are going to go forward, but the way we go forward should be colored by facts and not by lack of evidence, et cetera. Just so you know, I didn't have a lot of problems with the probate court system as it existed. I'll start with that. On the other hand, I wanted to be as open-minded as possible, and I'm still trying to be, about creating a better system to deliver justice to Maine folks. And if that's integrating the probate court system into the full judicial branch, so be it. And let's come up with the best plan possible. But I have to tell you, there are two observations that I find, and they came out in the rationale, and it even bled into the draft report, and I'll be specific in just a moment. It sometimes feels like we're looking through two different lenses. The state lens we're looking at for judging appointed judges. The national lens we're looking at for elected probate judges. Because if you put the national lens on appointed judges, you'd have a lot of questions, given all the things that are happening on the federal level. And so I'm just suggesting that appointed versus elected sort of gets mixed into a bag that isn't as important as we've tried to make it, in my opinion. However, I do understand that one thing we must deal with is the lack of a full-time probate judge, so that there's no longer a part-time judge practicing law. That appearance of conflict is strong in every report we've ever seen, and it is a perception that is also a reality, not a reality in terms of dishonesty, but nevertheless, it doesn't feel appropriate for anybody. So I'm not going to go over each of those rationales because I'm going to respect Representative Cardone's suggestion that these were just attempts to write down what they heard during the discussions. But it did bleed, for example, into the draft report. And as I look on the section on the introduction, we go right, and here's another example to me of a lack of understanding. It says that in addition, as the only elected judges in the state, probate judges are exempt from the rules of the Maine Code of Judicial Conduct, restricting the political activity of all other Maine judges. That doesn't say there's a very limited window of how probate judges may act when it's time for their election. We're certainly subject to the Maine Judicial Code of Conduct. In fact, we just had to buy insurance right now to insure ourselves in case there's an accusation by the Judicial Code of Conduct violation. So I'm just saying, I'm concerned that we have lost the plot sometimes with the rationale. I think it's very important that we go forward with the understanding that getting a full-time probate judge. I'm also concerned with the family court thing because that seems to be the most pressing issue. We try to address it with the home court rule. There's still issues there. And so maybe that's the part that is most concerning. So I'm going to go back to where I'm not trying to derail anything, but I can't in good conscience support a report that doesn't even understand what the probate court does and makes accusations about its behavior. I honestly think that I'd put the probate judges, the elected probate judges, up against any appointed judge in the state of Maine. And so since I feel so strongly about that, and I don't mean to be defensive, but I just think, I don't know anybody who knows more about wills, trusts, and estates than Will Avantaggio, and he practices law. And I remember the first meeting, we're not there now, but he said he thought, and you can correct me, Bill, I'm not trying to put words in your mouth, but what I heard you say, being an attorney made you a better judge, being a judge made you a better attorney. But you could also see both sides of that issue. And so that's the conflict that I have faced. So I don't mean to dominate this discussion because we've come so far and there are real issues that the chair, Senator Carney, asked us to talk about. What does the transition plan look like? And I want us to go there. I'm not trying to derail that. I simply have to tell you that I think that the rationale went way off the trail in terms of describing what probate courts do and what the real problems are. And so that's not going to get us very far with the solution unless we are true to the actual facts on the ground and use evidence and not anecdotes. So thank you very much for hearing me out, but it was just such a profound influence on my thinking that I just had to share that with you. Thank you very much for allowing me to speak.
Thank you, Judge Mitchell. Could I ask you a couple of questions? Because I had some of the same reactions that you did regarding the rationale document and actually that section of the report that you referred to about the Code of Judicial Ethics. I kind of went back and read that a couple of times, and I do think that, you know, we're fortunate that we actually have enough meeting time to go through the report and make changes that we think are really important. So I really appreciate you bringing this up. And I guess my question to you is, when you say facts and not a lack of evidence, do you feel like we need to add more facts to the report, or to take out the rationale sections which are not, I agree with you, not facts? And I actually think since our charge was to come up with a plan, and this issue has been studied repeatedly over the last 50 plus years, I'm not sure that we need to either have the rationale at all in there. But I'm just curious as to what direction you would go with regard to the concern about facts.
Well, I don't want to take the commission's time, but I went through the entire, I wrote down my comments on what's based on evidence, what isn't. So I don't want to take your time to do that, but if you wish to, I'd rather you get to what you wanted to do. But if you just review the rationale, there are many of them that jump off the page. Is where did this come from? Here's an example. Number 12, under reasons for supporting this, it's important to keep the probate court docket separate from the docket of general jurisdiction trial courts, prevent pushing estate and trust matters to the back of the list of prior. Oh, I'm sorry, I misread that one. My error. But the lack of specific education and experience qualifications to run for office as a probate judge. Probate judges are required to be attorneys. And so what do you mean? What specific education do you want? So that's just one thing. I just don't want to take up all your time, but I think we should go through all of them if they're going to be used. I mean, and then each person can weigh in on what they're saying. But there's just no evidence that, I mean, talking about what the probate court has, I mean, you keep talking about inconsistencies among courts. I don't even know what that means, because I don't think every district court judge rules exactly the same. We're so form driven, we have to follow forms. So I'm just concerned about the reason for the change. Go back to where you started this whole process. The reason for the change is you thought it would improve justice for Maine citizens if there were a judicial branch thing, and family matters in particular, that families had one place to go and they had judges that were appointed and vetted by the peers. So it seems like if we stick to our goals, then we can come up with a plan to offer. And then, of course, the legislature is going to have to make some choices. Judge Crockett has offered his alternative, and I asked for a copy of the resolve today. The title says it has to be a part of the judicial branch, but I think the substance doesn't say that. It's full-time judges. I think that's what Judge Crockett was saying. But there are lots of ways, and I don't want to derail it. You have two reports going on here. You have one report which transitions us, and I'm also concerned about the transition. We've said we're going to keep the registers out. We did it for good reason, because we respected their work and their ability to do the informal test dates, etc. On the other hand, the proposal for phasing in the judges themselves sounds like, oh my God, what a mishmash. We've got partially state probate judges, we've got elected probate judges, and we have county registers. And I am concerned about creating a train wreck. And so it's all of those things that concern me. And again, you could go through each of these if you're going to use bullets at all, but maybe we should start over and say why we're doing this and not worry about those things which do lack evidence.
And that's what I was trying to get at is, do you feel a need to incorporate more facts, or do you think that the appropriate direction to go with regard to the report is to jettison the whole idea of including a rationale and simply tighten up the report to eliminate things that seem like they're not fact-based?
This is the last time I'm going to talk, because I want everybody else to weigh in. I don't think you can eliminate rationale totally. Why are we doing this? Has to be there, but it can't be my opinion, Kathy Ayer's opinion, Justice Gorman's opinion. What are we doing this for? And at least have some evidence-based reasons for doing it. Obviously, we go back to the histories of reports, the constitutional amendment that changed things. Why are we doing it? And I know we're at the end of the train here and we're getting off at this station, but at the same time, that's what's important to me. Create the plan, offer it to the legislature, but give them the reasons we're doing it. They haven't had the benefit of sitting on a probate court, of sitting on the law court, or even going before a probate court ever. And so we have the opportunity to share our vision and our wisdom, but it has to be concise and it has to be a reason for doing it. You did part of that when you passed the resolve. I mean, that in itself has a rationale, but then let's be careful with any things that you put on here that are not fact-based, because it's very insulting, frankly, to the probate courts, and it's just not true. Sorry.
Thank you. And Justice Gorman, I know your hand is up, but Representative Cardone has been waving her hand next to me for a couple of minutes. So let's let her speak and then we'll call on you. Thanks.
I wanted to say a couple of things. Judge Mitchell brought up the transition plan, and we're going to talk about it in more detail later. But what I said about this draft and this rationale also goes for the transition plan. Senator Carney and I discussed a possible transition plan based on some of the information that we had that we wanted to put down on paper for you so that we could have something to discuss. It is not something we agreed on, that we voted on. It's something we want to discuss. We want to come up with something that we've all shaped. And if you all decide that what we wrote down stinks and we need to go to something completely different, that's okay. And we'll talk about that later, but since Judge Mitchell brought it up, I wanted to make that clear. The second thing was, did we lose Mr. Delicata?
I think we may have, and we also gained Catherine Wiltuck. So we should ask her to introduce herself at some point.
Okay, I had some communication with Leo Delicata yesterday about this issue of the rationale. And he had sat down and actually worked out and proposed some language. He didn't share it with the commission, and I didn't feel that I should do that, but I wanted to ask him to speak up and if he's willing to share what he had put together, because I think that it did a good job of going back to the statute, taking the language from the statute and the language from the resolve as to what we were requested to do and putting that forward as our rationale. So I'll wait. If he doesn't come back on, I'll try to find it and see if I can share it with people.
Thank you. Justice Gorman, go ahead.
So I don't know that this is in response to Judge Mitchell, but I understood that our task before today's meeting was to go through the rationales, which really are a compilation of things that were said during the meetings, and come up with those that we agreed with, those that we didn't agree with, and then decide whether there's actually a consensus of things that we agreed with that should be included. I'm seeing this as sort of in the same way that sometimes judges get a request for further findings of fact and conclusions of law. This is one of those. So we're being asked whether there are actually statements that we should include that support or explain why we have gotten where we've gotten. So to address what I agree with Judge Mitchell, I mean, there's lots of things in here that they were just sort of comments that we made, and this is no criticism of Sam or Janet. That was their task, just sort of gather everything that were said. But I think it would be pretty simple for us to go through and simply say which one of those which of the list of things are accurate, or which one of those we either want to adopt or adapt or throw away. So it may be a relatively quick exercise if we just go down through that.
Thank you. Judge Avantagio?
Thank you. I haven't seen what Mr. Delicata drafted, but from my position, we don't need much more or anything more really than there was this vote in 1967. There was this authorization for this commission to make that happen, and that's what we're doing. So whether it's working, not working, approved, not approved, it doesn't matter. There was a vote in 1967 to incorporate the probate system into the state system. There was a resolve that's in our books that created this commission, and that's what we're supposed to be doing. So I think that the information about what works and doesn't work is important to how we package this and present it, but it isn't really important as a justification or for why we're doing it or whether or not it needs to be done. I don't think there needs to be an agreement or a resolution on whether it needs to be done. It's been voted, and we've been tasked to give them an idea on how to do that.
Thank you. Judge Crockett?
Thank you. I think I would echo Judge Avantagio. Really, the rationale behind it, what they were looking for was a plan on the how-to. I think Representative Cardone was instrumental in drafting this resolve, and I think your goal was just to give a how-to, a plan. So rather than spend a lot of time on the rationales for this, just focus on the plan, and at least there'll be a good product that comes out of today's meeting. I wouldn't waste any further time on the rationale, but that's just my 2 cents, because I obviously don't support the plan, but I do want to be fair.
Thank you all for your contributions. Are there other comments by commission members on this concern? Maybe while we're thinking about it, Catherine Wiltuck, would you like to introduce yourself?
Hello, sorry I'm late. I'm Catherine Wiltuck. I'm a Director of Court Process Planning and Services.
Thank you very much and welcome. Other comments on this, the incorporation or not of rationale? Go ahead, Senator Kime.
Speaking as a legislator, I think that without reasons or rationale, it's very difficult to take a report and understand what went into it, and and then decide which of the recommendations the legislators themselves would agree with or would disagree with, or there isn't a good way to question it. I do understand that we're working off a vote that happened in 67. And I sent out an email earlier today because I'm not going to be on this meeting all day, just for a bit this morning, explaining my opposition to this, which I think maybe now is a good time for me to share, because I do believe it needs to be part of the record as well as an email, but I didn't want to feel like I was monologuing for too long. But so if you think it's appropriate, I'd just like to share that right now before we move on, if that's okay with you.
Yeah, let's just take a moment and see if there are any other comments on the rationale document before we do that.
Sure.
And I did want, it doesn't look like, I'm not seeing any hands up, but I did want to also comment on it. I agree significantly with those who say that the decision was made when the constitutional amendment passed in 1967, but there have been a lot of studies since then. They have all pointed in the same direction. Our charge was to come up with a plan, and so I think it's really important to have our report focused primarily on the plan. But I do think that the points that I think Justice Gorman and Judge Mitchell raised, having to do with the benefits that Maine people see from making this transition, should be included in the report. And I think back to a bill that was heard in the Judiciary Committee earlier this year, related to participation by probate court judges in the training opportunities offered by the judicial branch, and an effort to allow probate court judges to participate in that training, and all of the reasons why the judicial branch didn't think that was appropriate. And to me, that just really highlights that Maine people and Maine judges will benefit from the transition that's incorporated within the plan. And I think we need to have some of that overarching policy information in our report. Any other comments on the report and the rationale issue? Go ahead, Register Ayers.
I just can't keep quiet, apparently. I do think some rationale is needed, but I do think we need to keep it on the positive side, not some of these things where talking about inefficiency, ineffectiveness, and that kind of thing is not fact-based. It's not. And I that's the kind of thing that I don't want to see in this. I'd like to see a more positive, what are we going to do for the people? I can tell you very much that it's very hard to find people to run for our jobs now, because this kind of legislation comes up every 2 years. And are you going to have a job? You have to get elected. Then are you going to have a job? Are we all going to be fold? Are we going to be state? This is the employees. And it's very hard to get good people to take these jobs if they think their jobs are going to be cut or endangered. And I want to stay on the positive side of what is this going to do for the people.
Thank you. Other thoughts or comments that commission members would like to share? Go ahead, Representative Cardone.
I just wanted to say I've been communicating with Mr. Delicata, who has lost his email lost his internet connection and will join us as soon as he can. Sam and Janet, I think I'd like to forward his email to you guys so that when we have a discussion about the rationale, we can use what he has put together and contributed, or we can add that to our discussion. But he said he'd try to rejoin us as soon as he can, when his internet comes back up.
And here he is. Welcome back, Leo Delicata. Are you okay? We're discussing the rationale document and people's feelings about what to include and how much to include. And you had thoughts on that. Would you like to share them now?
Yes, hang on. I'm very sorry. Anyway, I do have thoughts. I have dogs also. Excuse me, I just got to take care of this. I'll be back in a minute. Come on. Come on. Come on. Come.
It's a dog eat dog world out there.
Feels like home.
Yes, it is. It is home. These Zoom meetings have their challenges. So, you know, I really do tend to, I haven't heard the discussion, so I don't know what's been said, but, you know, I do tend to agree that a lot of what has been expressed in that document is really not necessary to our mission. You know, this commission was voted by the legislature as a way of determining how to effectuate the constitutional amendment that was voted by the people of the state of Maine in 1967. To me, that is a seminal event, and it's not an event that should be ignored. You know, anytime the people of Maine vote to amend the Constitution, which is the legal basis for who we are as a society, that's important. And the fact that there have been so many commissions over a long period of time that have seriously grappled with all of this and almost uniformly have identified an ethical issue with respect to the probate courts that needs to be resolved. And you know, for me, ethics is a very, very important part of who I am and what I do, not only personally, but professionally. It is the basis for our whole system of justice. And I really do think that what we have done as a commission is to respect both of those thoughts, that the people of Maine voted to let the legislature, or ask the legislature, to create a system with full-time judges. Well, you know what? We've done that. And I think we've already also taken a lot of steps forward with respect to understanding why the probate court is so important to the people of Maine and why it has been accepted and supported as much as it has. And that has to do with the registers and what the registers do and the kind of customer service that the registers provide to people. The registers are the backbone of the probate court. I'm not saying that judges are not important. They are important. They are absolutely important. But the registers and the way registers interact with people is not something that the people of Maine want changed. Even if the idea of registers at some point in the history of the world is brought into the judicial branch, they don't want to lose that customer service component. And I think we've done that too. I think our commission report says that clearly and offers enhancements to the mission of the registers and their staffs. I think that our commission report also respects the needs of the counties by making sure that some of the burden that the taxpayers now have as property taxpayers are shifted to the state. And there are so many things about how we've thought carefully about a new system. And it's a new system because our laws have changed and evolved over time since 1967. Registers never had the authority and the ability to make the kinds of decisions and the kinds of changes that they make now in 1967. We've seen all that evolve. And we've also seen how different counties have different needs in terms of the judging function and how much time it takes in certain counties and how many cases we see in certain counties. All of that we have carefully looked at too. And honestly, we've looked at the needs of the judges, not just the needs of the system, but the needs of the judges. Why should anybody have to choose between a practice of law and the profession of being a judge? That is a career decision. In some countries, you have to go to school in order to be a judge. I have relatives in Italy who are judges, and they have a course of education after law school, and it's a period of years to assist them in becoming judges. And we don't do that here, but at least I think we are respecting the idea of judging as a career choice, judging as something that is very important. So I think our mission is not to decide yes or no. Do we go forward or don't we go forward? I think our mission is to create a plan to go forward. We've done that. We don't need to explain why there are good reasons and bad reasons for going forward, which is, I think, a lot of what we saw, what I read in the document that we're talking about. I think that what we need to do and what we have done is given the legislature a clear, thoughtful plan that meets what our mission is. And so I would be more than happy to go through this report and take out anything that is questionable, that lacks evidence in terms of the rationales, that suggests in any way that our probate court is somehow giving inferior service. I think that we've identified some issues. I think we have addressed those issues carefully. I think there may be some disagreement. I know there are some disagreements about some of the decisions that were made, but they were not decisions based upon any idea that the probate court somehow is so terribly wrong that we have to identify and underline and whatever, deprecate the work of the probate court. That's not our mission. Our mission is to provide the plan. We've done that. And I've spoken too long now, but part of it was because I'm really frustrated. I was offline, couldn't get back online, couldn't hear the discussion, dogs running all over the place. I mean, come on, it's been a morning already. So I'm going to be quiet now. Thank you.
Leo,
Yes.
in your absence, I emailed the attachment that you sent to me yesterday. I emailed it to Sam and Janet. Do you want that distributed to the rest of the committee?
Honestly, I don't think it would help at this point. And it really is a restart. What I've just said is sort of an expanded version of just brief comments. And the brief comments were, this is our mission. We've done our mission. There's no need to add things to our mission that are could be misinterpreted, that lack evidence, that are, really the only reason you would put them in to illustrate the discussion is for historical purposes. And you know what? I've read enough reports. I've read enough commission stuff since 1952. We don't need that in our report. So that's basically what it is. Thank you.
Thank you, Leo. Does anybody else wish to be heard on this topic? Go ahead, Judge Martin.
So I guess I'd go back to, first of all, Judge Mitchell, I agree. I think we need, if there's anything reasoning that's included in here, needs to be supported with some evidence. We can't just say how we feel and it goes into a report. I get that. And I certainly think that now hearing from Senator Kyman, I'm not sure what Representative Cordone or Shaheen or Senator Carney feel, if they feel the same way, is that they need to hear reasons. The reports that I've seen in the past do have reasons that support the recommendations. So I do think it's necessary. And if we're hearing from legislatures on this commission that that's something that they need in order to make some determination, it may be appropriate to go through these and as a commission determine which stay and which go. That's my 2 cents.
Thank you. Go ahead, Senator Kyman.
Thank you. Yes, I appreciate Judge Avantagio's perspective that if there was a vote taken in 1967, I believe it was him that said, then that's the only reason we need to, move forward with recommendations, and that could simply be the only reason. However, the legislature never did, move forward with this at a time when apparently it must have been a large concern enough for them to vote. I don't know what was going on at the time. But I do want to share my reasons for opposing this. And it's mostly because while it may have been something that did garner statewide attention back then, and there must have been issues to push that forward, in the time that I've served in the legislature, I rarely, if ever, hear from Maine people who have issue with the probate court. In general, I find that people think it's serving them well. And that's, it's my job to listen to them. I think it's mostly some members of the bar and academics who come time and again and want to see it changed, and improved based on their perspective. But I would say that it might be different than the perspective of the people of Maine. And then if the people are not coming forward and telling their legislators, hey, this is a big problem, we want this to be changed, then legislators are not going to have a burning desire to invest the taxpayers' money into a system to change it. In general, I think people are being well served in probate court. And I do agree that the conflict of interest, the appearance of conflict of interest is a concern, and that it would be good to do away with part-time judges. I think that is definitely an area where everyone, there's widespread agreement on that issue. But again, the funding of it, because even though there's an appearance of conflict of interest, because there doesn't seem to be widespread issue with it, there doesn't seem to be an appetite for funding that change. So I have been in and out and not as involved in this as others have been, but I wanted to make sure that I was sharing with you all what I've seen after, having served for years on the Judiciary Committee, and make sure that that perspective from the people of Maine is also heard and taken into account as this overall plan is considered. And that way there's also an understanding, I think, for the commission members as well, of why there's a reluctance on the part of legislators to commit this type of money.
Thank you. Judge Crockett, I know that you also did not vote for the plan. You voted against the plan. Did you have any additional reflections that you wanted to share with us at this point?
Well, I don't want to take up the committee's time because I know that the vast majority of the committee believes in this plan, and I want to make sure they get a good product out, because even if I disagree with something, I still think it ought to have a fair chance. Some of the findings I don't necessarily agree with, but I've voiced that concern before, like the judicial economy and the use of resources, the allocation of judicial resources, so forth. There's some logic I don't agree with there. In terms of my minority report, I'd like to pose this question. I guess I could be a minority of one, because I've already stated I support the total integration of the probate courts into the state system. I do not support this. And some of my more recent research revealed that we are basically reinventing the Ford Pinto. I know we talked about the Cadillac version being the total integration, but we are actually creating a system that was in existence in the 1970s and required the fixing by the judicial branch in the 70s. So it's kind of like a Back to the Future moment. We're bringing back 8-track tapes. And the cost that has been that we could derive from our current proposal will automatically require another additional infusion of money to get to the final answer, which is inevitable, because some of the same problems that we fixed in the 1970s, we're going to be required to fix again if this were reinstituted. So if the intent of the commission is to create a situation that requires fixing and a second infusion of money, then this is the right proposal. I'll tell you, it's analogous to when they build Air Force bases. They oftentimes build the airstrip last. They build a lot of the support facilities first, because they know if they run out of money, they have to come up with more money to put the airstrip in, right? Because what good is an Air Force base on an airstrip? Well, that is sort of what this plan does. We're going to spend it between a minimum of 6, more likely 7 or 8, top of and up to 10, when the entire integration could probably be done for another 50% of that. So I think, and we're going to have to fix it almost immediately, because the HR issues alone that were created, that were remedied in the 70s, we're going to have to remedy again. So I don't see, you're creating a state probate court system staffed by county employees. and non-union versus union. There's labor issues. There's going to be indemnity issues. The counties aren't going to agree to it unless the state takes on liability for, potential workers' comp, for any sort of HR policy, any misconduct by state employees towards county employees. It's going to be a show. So I'm opposing it. I'm proposing a phased approach with the 8 full-time probate judges paid for by the state, 1 chief justice. And I'd like to, if I can get the permission of the chairs, to throw in just an annex or a footnote with a minority view, because I'm not sure that every judge necessarily, every person who's voting against this plan agrees with me. So I don't want to suppose that I'm speaking for anybody, but I would like to throw in, why I'm disagreeing with this, and understand you can tuck it away in a footnote, but I do believe in the integration of the probate courts. I tend to, the Constitution's important. People voted on it. It needs to be respected. And I think that was the charge of this commission. And I do support the Cadillac version. I do not support what is the reinvention of the Ford Pinto. In my humble view, I'm obviously being a little bit humorous in my feeble attempts, and I'm not very funny, so forgive me. But I think that I think that's where my views are, and I don't want to waste the commission's time, because I really want to see you get the plan out to the best of the commission's ability. But if you have any questions, let me know. I'll just stand by.
Yeah, thank you. I appreciate, we all appreciate everything you've said. And yes, please do provide a written description of what your report would be, because we will include it in as perhaps an appendix, I would envision, to the report, since you have a different vision for the implementation plan that we're charged with preparing. Thank you. We've come a little far afield from the rationale document. I do want to lead us back to that to review it. Judge Mitchell, your hand was up. Go ahead.
Yes, please. I'm probably riding in a Ford Pinto. I don't know. But here's an example. Judge Crockett has said he supports the full integration, and he thinks we can do it for half again as much. We don't know that. On the second meeting, we said we can't do this because it costs too much. Should we have had that discussion? And maybe it just bothers me. That's an example of, we made the assumption and said we can't afford to do the whole thing, and we probably can't. But shouldn't we know that? I don't know what the numbers are.
So I thought, and maybe this is a clarifying question for Judge Crockett, I thought that what we decided was that it was important at this time to preserve the existing register system, and that was the piece that we weren't, that's why we were a Pinto instead of a Cadillac. But Judge Crockett, can you illuminate us?
I think, Madam Chair, I think I do remember that statement, and I think half the commission went along with that. I took the view that the entire system ought to be integrated, and the register should have certain training. I think Justice Gorman alluded to that about 2 or 3 meetings ago, and I agreed with her. I believe in the total integration. Granted, I love what the registers do, but I do not think that it cannot be achieved if the right amount of money and resources were put toward it. And I think there ought to be one system. I don't like the idea of 16 different county systems and one state system. But that's my academic ideological side speaking. The reality is I don't think we can financially support that move right now. So that's why I'm going with the moderate 8 probate districts approach that we can get through at about 1.7 million, as opposed to the 7 to 10 million annually. So for the model you're proposing. And again, that math is based off the estimates we've got from Indigent Legal Services, which put 4 million. 8 judges was 1.7, but the current proposal has 9, which, figure that's 1.9 million. Then you have your marshals, you're going to have your support staff, your IT,
Yep.
plus your leasing of spaces. So that's where my numbers are coming through. And that goes to Judge Mitchell's point. We don't have thorough estimates yet. So it's hard for me to write my minority without sounding foolish, because I think the only number I'm relying on is that 1.7 for my alternative proposal. The rest of it is why I'm opposing it, because I don't think 10 million or 7 to 10 million annually for half the product is necessary. So, but I don't know if I answered your question or I made it even more confusing.
No, I think you answered it, and please, I would encourage you to submit a document, minority report, whatever you would like to call it, that we can attach as an appendix to the report. Go ahead, Representative Cardone.
I do want to get back to looking, going through these itemized rationale, but I just, in response to Judge Mitchell, and this is more my view as opposed to anything we discussed as a commission. I do think, Judge Crockett, that it's too expensive to do. I agree with you that I would like to see a global incorporation of the probate system, including the registries of probate, into the state court system eventually. But I felt it needed to be done in increments. One reason was cost, but frankly, the other reason that I thought about is just the complexity of doing this. I know Julie Howard's not with us today, but as she said, and I believe Justice Gorman said, there's no analogous office to the registry of probate within the state court system right now. I mean, the closest thing is a clerk of courts, and we all agreed that it wasn't the same thing. And I think it's going to take some careful studying and understanding of what that incorporation of that system is going to need, is going to cost, and how it should be done, so that we don't screw it up. And it just feels to me like it was too complex for us to deal with in the 4 meetings that we have. I'm not saying we shouldn't be doing it later on. You know, whether it's 2 years from now or 3 years from now. And I think our goals, that the draft goals that we have in this report, support what I was thinking, that this is something we do have to do. We do have to get the Ford Pinto up to Cadillac eventually.
Thank you, Representative Cardone. Judge Crockett, we really need to shift our energy back to the rationale document and decide what we are or aren't going to include. Also give you a moment to just have your last word on.
No, I just offered a quick thing. One of the things I did not realize was that the Superior Court clerks used to be elected. That came out.
You know, I'm gonna.
So there actually was an analogous situation.
Yeah, thank you. Thank you, and I appreciate your helping us transition back to the rationale document. So there's 2 ways that we can do this, commission members. We can go through each long-term goal rationale, or we can have kind of a global discussion about what rationales we want to include. So one direction could be to, as Register Ayers said, and I agree with you very much, Register Ayers, is to list the positive rationales for the change that we're going to make and leave it at that. We could go through the rationale document and edit it and decide what we're going to keep in and keep out by majority vote, or we could just really focus on the narrow rationale, which relates to the constitutional amendment and the charge that we were given by the legislature in the resolve, as Judge Avantaggio had highlighted. And so do folks have thoughts about which approach we take? So lift out the positive, go through the rationale document one by one, or have a narrow focus on our charge? Comments, thoughts? or another option if there are other approaches. Go ahead, Justice Gorman.
So I'm mindful of what Senator Keim said, that it would be useful to have some rationales with your report. So I do think that we should, to the extent that there are any recommendations in here that we can agree on, include those with the report. And I just don't know that there are any in here we'll be able to agree on, other than the first one, which is that a number of studies have recommended integrating, and there's a constitutional resolve. The others have to do with anecdotal information and some personal opinions, and I don't think they are necessary to this.
Thank you. That's a good way to start off. So other comments on the approach that we should take, or I can lead us in looking at each one of these and determining whether there are items that we can all agree on. Go ahead, Leo Delicata.
Yes, I'm thinking that this long-term goal, as it is that very first goal, when I first read it, I basically looked at it and said, wait a minute, this probably ought to go into the last section where we talk about a review in 3 years of where we are and where we're going. The charge that we have, the mission that we have, is not to create a plan that fully implements the probate court system and transfers it into the state system. That may very well be where we end up, but certainly there are lots of issues that have to be solved before we can actually do that. Money being an important one, but not being perhaps the dispositive issue right now. And so what we're charged to do is to create a plan with full-time judges. And if you look at the duties in the statute, it provides, there are a couple of words that provide rationale for what we've done. So, I mean, my preference would be, no matter how we deal with this document, that we take that first long-term goal and accept the fact that it is a long-term goal, but it's not one that we have the direct, we have a directive to accomplish in our work. So I would put it at the end. I would put it at the
Yep.
The revision.
I would disagree with that. I think that's a moderately tortured reading of the constitutional amendment that says integrate the probate court system. This one says create a plan for a probate court system with full-time judges. I don't think that with full-time judges is a qualifier. I think it's just something that has to be done anyway. But I'm troubled, as Judge Crockett is, that we're saying, well, let's just talk about this part of it and we'll deal with the rest later, because it seems like that's just going to create a problem. And it sounds to me like Judge Crockett's determined that they may have tried this in the 70s and created a problem. I would love to hear more about that, but I don't know whether there's time for that on our mission today.
Yeah, thank you. The expression of a long-term goal is something that we had discussed and incorporated at the beginning of the plan that we voted on 2 weeks ago. And I want to focus commission members not so much on the goals and recommendations that are in the grayed out boxes, but the reasons that are listed in each one, because that's really the heart of the rationale document. And I would just like us to go through for each set of numbered points underneath of the grayed out boxes, lift out the ones that we as a commission feel comfortable including, eliminate those we don't, And then if there's some other one that we feel like we want to include and that we can all get behind, we could include that. And so for the first under long-term goal, there's 5 reasons that were mentioned and have been listed by the analysts. And so the first one, studies in the past 60 years have recommended integration. Is that something that we all can agree on to include as a rationale? Okay, is there anybody who thinks we cannot? Then shake your head this way. No. Okay, good. The second one, the decentralized nature, variations and inconsistent interpretation of the law. I cannot support that. And so we're going to eliminate that because many of us I'm seeing can't do that. Okay. Number 3, funding a complete transition in one fell sweep would be cost prohibitive. Do we feel that it's important to include that? I'll just throw this out there. I kind of think it's important because it explains why we chose this path as opposed to a different path.
Yeah.
Go ahead, Judge Mitchell, and then Judge Crockett. And we're not able to hear you, Judge Mitchell.
I just wanted to add, that's just part of the sentence, because what you said earlier, we were talking about, you thought it was important to phase it in for reasons of efficiency and less disruption to public service. So it seems like it's a two-pronged statement, not just money. It's also the reality of being able to do it in a couple of years.
Thank you for that clarification. Do commission members agree with adding that second part to paragraph 3? Yeah, okay, I'm seeing lots of nods. Judge Crockett, I think you had your hand up next.
I just posed the question. It's cost prohibitive, I guess, I'm speculating, but what is the cost? After you estimate what you just came up with for a plan, how do you compare the two? Because this plan has leasing of spaces, marshals, everything else. Only thing it's missing is some of the county employees. So what is the difference? How do we know we haven't just spent 3/4 of the money to achieve the same thing?
It is a creature of the imperfect nature of the legislative process where we don't get a detailed fiscal note until after the legislation is well on its way through the legislature. And we're just going to have to kind of live with that uncertainty.
So rather than make it a finding, wouldn't you make it a speculation? Saying it's speculative that the total integration would be far more expensive than the plan, but you don't really know, because I think you're actually 3/4 of the way there. But I don't know that, but I'm just doing tabletop math, which scares me that I might be the only one doing it.
Yeah, I think it's important for you to include that in your submission. Register Heirs, I think you were next, and then Justice Gorman.
No, I was just going to say that, yeah, it would be a much bigger cost because we have our historical records and the county owns the images in the system. So to say that it would not be more, it'd be a lot more because it's our staffs as well, our full staff. So that's all.
Thank you. Judge Crockett, I think we all appreciate and understand your point, and I'm not trying to stifle your contributions, but I feel like we've heard your concerns and we need to kind of move on to some of the other points that need to be made. Go ahead, Justice Gorman.
So I think we can hedge our bets a little and simply say funding a complete transition in one fell swoop may be cost prohibitive, and then add what Judge Mitchell recommended with regard to it's, I guess intrusive would be the wrong word, but it would be problematic to try to do everything in one fell swoop.
Yeah,
both for money and for resources and for people.
Yep, I think the words were efficiency and less disruptive to public service.
Disruptive to public service.
Which I think are really great. It's a great way to capture it.
Yep.
Point number 4, and I'm going to kind of do this by process of elimination. Are there if any of us objects to including rationale number 4, then it's out. Are there those who object to number 4? Okay, it's out. Number 5, the existence of 2 different court systems is confusing to the public, especially when dealing with different aspects of family matters. Is there anyone who feels that that should be excluded? Go ahead, Judge Avantagio.
I don't recall hearing anybody say that. There was one member of the citizenship who gave a long history of her trials in the court system, but probate seemed to be, from my hearing of it, the one that fixed it when she finally got to the right place. But otherwise, I haven't heard that.
Thank you.
I did miss one hearing. I will append by saying that.
Okay, well, let's check in with everybody. Commission members, do we feel comfortable excluding point number 5? Go ahead, Tudor Goldsmith.
I don't think it's necessarily that important that we include it, but at least in my own experience, I do feel that having a family case removed from one court to another in the midstream is extremely disruptive to the individual family that's going through it. In this case, for me personally, it was, as an attorney, it was a minor guardianship, and it delayed a case that could have been resolved in months. It delayed it for an additional year, which is a lot of time for a 3-year-old boy. So I do think that there are some cases where this is true, although I think that the way this is worded might be a little bit broad, at least in comparison to my perhaps more limited concern.
Mm-hmm. And would you be okay with us not including number 5, Tudor? Okay. Is everybody okay with not including number 5? Okay, I'm seeing lots of nods. All right. Now we're going to move down. And then before we move on, is there any other rationale related to the long-term, the fact that we support a long-term goal that we want to include? Not seeing any hands up. Okay. The reasons for opposing the goal, I feel like since we're only including things that we each agree on, and that that we're not going to go to the opposing issues. The recommendations regarding the 9 full-time appointed judges, we're not going to review each of those that long paragraph of recommendations, but as far as the reason for supporting the recommendations, so that's the 12 numbered points on page 2. Let's start with the first one, which is the simple recording of the fact that there was a constitutional amendment approved by the voters of Maine in 1967. Is everybody good with keeping that in? Okay, good. All right. Second one, the fact that part-time probate judges practice law and represent clients in other probate courts and state courts. Numerous studies have recognized the potential for conflicts of interest and appearance of impropriety caused by this practice. We have a couple of ways to go here. We could decide to exclude it, include it. We can also modify it. And so I'd like to have feedback from members of the commission on that.
I think it's fine the way it is.
Will you turn on your mic? Thank you.
I think it's accurate the way it is. I don't think anybody disputes the appearance of impropriety and potential for conflicts in the system.
Do others, is there anybody who has a concern about including number 2? I'm going to specifically ask the probate judges because of course this, this it speaks about the jobs that you currently have. Are the 3 of you comfortable with including paragraph 2?
I am.
I see Judge Mitchell and Judge Avantagio are okay. Judge Crockett?
Yes, I guess I am. I mean, I'm not, it says reasons for supporting the recommendation. I don't support the recommendation, but I do actually support that particular thing. Thought.
Okay, so we'll keep that in. The next one, the judges being distracted or overwhelmed, I personally could not support that one. Okay, so no, okay. Full-time judgeships are likely to attract a larger pool of high qualified applicants. I also don't, I'm seeing lots of no's to that one. Difficult to determine the precise number of judges needed from the data gathered by the commission, so it makes more sense to assign courts and reassess. I feel like that's kind of getting into the weeds and that we don't necessarily need that much of an explanation. Are people okay excluding that?
Yeah.
Okay. Number 6, assigning one judge to each region preserves the beneficial regional familiarity. Is there anyone who wishes to exclude that? I feel like that's a pretty positive statement. Any comments on it? Are we okay with including it? Number 7, this is one that I think Judge Mitchell raised a concern about, lack of education and experience qualifications. Are we comfortable excluding that?
I want to exclude it.
Okay, lots of agreement on that. Probate judges are the only elected judges. Their qualifications could be screened and they should be appointed using the regular system. That's number 8. How do folks feel about that one?
I think it should be out.
Okay, Representative Cardone would like to exclude it. Are people comfortable excluding
Yeah,
it?
I think it should be out. I think it's more our conclusion rather than our rationale for a conclusion.
Everybody okay with that? Okay. Number 9, the public perception that elected judges are less independent than appointed judges. Okay, I'm seeing lots of excluding head gestures. Okay. Number 10, a chief judge responsible for unifying court practices will help alleviate the concern with variations in process. Go ahead, Justice Gorman. But we're not able to hear you.
I would recommend an amendment to this, a chief judge responsible for assisting in the transition would be useful, but I don't think we need to say that it's going to alleviate the concerns, blah, blah, blah. It would be helpful to the transition.
Thank you very much for that language suggestion, and that's great, keeping it on the affirmative and positive trajectory. And is everybody happy with that clarification? Okay, looks like we are. So we will wordsmith that. Number 11, probate judges would benefit from the assistance offered by trial court judges, including law clerks, IT support, and security. Are we comfortable including that? Judge Mitchell?
Just having trouble with the word greatly. We'd probably benefit, but I don't know how greatly, particularly the IT and things like that. So if you had erased that, I'm okay.
All right. We are greatly is out. Any other comments on that one? No, okay, good. All right, and then 12, keeping the probate docket separate from jurisdiction to prevent pushing estate and trust matters to the back of the list. Do we feel comfortable excluding that one? Justice Gorman?
So I think one of the reasons we talked about keeping it separate was also for purposes of data collection. If separate within the JB, because we did talk about keeping the docket separate, even if the judges were part of the JB. If I'm not misremembering what our agreement was, because we do want to be able to have data to show whether this is working or not and how to tweak it going forward.
Okay, thank you. And Tudor Goldsmith?
Yeah, I think number 12 is important. A lot of the people that I've spoken with about this, practicing attorneys, have expressed concern about the idea of the probate court just becoming too enmeshed with the current judicial system for this exact reason. And I think one of the real strengths of the probate court that's been identified time and again during these proceedings is the fact that a lot of different tasks can be done quite quickly in the probate court. And I think if the two systems are completely merged, then those things will end up taking lower backseat, lower priority to other judicial matters. So this one I personally think is important. I think it preserves one of the strengths of the probate court as it exists now. And I would also, since I'm already talking, I did want to go back to number 3 for a moment. I don't think number 3 as it's currently written is good. I think it assumes a lot and makes some negative inferences that aren't supported. But I do think there's a nugget of truth in there that should be included, which is that there are a lot of part-time judges that are doing full-time work. And that seems like a big problem to me.
Okay, let's take those in chunks. Judge Mitchell, did you wish to be heard on this?
I'm going to go to chunk 12. Frankly,
Okay.
when I read that, I don't know what it means. I like the idea. I think the concept is important, but I don't want to wordsmith it as a committee, but just at least massage the words so that we understand what we're trying to do to keep it separate in the judicial branch to accomplish certain goals. It's just difficult for me to read, to know exactly what we meant. Although, as we've talked about it, I know what you mean.
Mhm. Yeah, I was working on sort of a little bit of a wordsmithing, maybe to say that it's important to keep the separate docket in order to ensure that estate and trust and other probate matters receive the appropriate priority or something like that. So emphasizing, ensuring that they receive priority as opposed to the inverse. Are people okay with that?
I think that's a big solution.
Okay, and we'll add the point that Justice Gorman made about data collection and to ensure that the system is working. Jumping back to number 3, Tudor had raised a point about including that concept. Are there others who feel like it would be important to do that? The part-time salary judges being distracted or overwhelmed because they maintain a law practice. And Tudor's point was a little different. Do you want to restate it, Tudor?
Yeah, my point was not that judges are distracted or that they're not doing a good job or anything like that. My point was that we have in certain counties in particular, I think, part-time judges receiving part-time salaries who have to also maintain, in many cases, other work, who are doing a full-time judicial caseload. If there's full-time work, they should be receiving full-time salaries and they should be allowed, to have dinner with their families at the end of the night, go on vacation and do normal things. They shouldn't be forced to maintain a separate career to support an insufficient salary when they're doing a full-time job.
So they're working full-time as a judge, but not being paid adequately. And so they add to that a private law practice. Is that the point?
Yeah, and I think we
Okay.
could even just leave it at the first part of that a full-time caseload requires a full-time salary, and leave it at that. And that way there's no, question about the inference of whether they're, making other decisions that affect their ability to do it.
Judge Mitchell?
I guess I don't support that. I guess I've seen a history of judges who prefer to be part-time, who love to practice law. That might be inconceivable to those of us who think that that's inconsistent, but that's not the case. And they are able to separate the two. And I don't know why we're going to step into that, because the implication is that only a person who is a part-time judge can be a judge. And I don't think we're going to come to an agreement on that. And I just wanted to express my concern about what you're saying, that you can't practice law and be you've got to be a full-time judge to be a judge. And I don't think that evidence bears that out. Perhaps you found a couple of incidences, but these are anecdotes again. I don't know what Lincoln County is like, but I would bet you that Will Avantaggio runs an excellent law practice. And I know from experience, he's one of the best probate judges that Lincoln County has ever had. So I just can't get into that mindset. And I would not be supportive of that unless you totally reworded what you're trying to say.
Yeah, I feel like this is one that we're not going to all be able to agree on. Tudor, did you want to speak to that again?
Yeah, I'm fine with leaving it out. My point was only that when we looked at the hours that judges were reporting, there were a lot of judges who were reporting full-time judicial work. That's all. I'm just saying if somebody's doing full-time judicial work, they should be compensated as such. And if they have the ability to do something within the canons, the judicial canons, to work outside of that, that's their choice. But it just doesn't make sense to me that somebody who's doing full-time work is receiving a part-time salary and potentially put in a position where they may have to make a decision about allocating their time that they don't want to make. That's all.
Mm-hmm.
But if the wording of it's bothering anybody, I don't think I was saying anything controversial or offensive, but if people are not comfortable with it, that's fine by me.
I didn't mean to say that you were being offensive, but I'm just saying it's not the full picture. Some of us are retired from the practice of law, and I'm not saying you want all retired people to be judges. We've already made the leap. We're going to full-time judges. So that's not even an important point anymore. And so why to make a denigrating remark about judges who are doing both? It's uncomfortable to me. That's all. And I apologize if it is, but it is.
Register errors?
Can we just have a different sentence that says, we want judges to be appropriately paid for their work? They're not getting paid for their work appropriately now. They're a bargain. And if there's some way that we can say that in here, I guess that does need to be said. I mean,
how do people feel about including that? Are we seeing? I'm having a hard time reading the faces here. If you are in favor of including a rationale point that speaks to ensuring that judges are appropriately paid for their work, please just raise your regular hand. Okay, that's kind of a mixed, so I think it doesn't make the cut. So what we've got for the second, the list of justifications on page 2 is number 1, number 2, number 6, and then 10 and 11 with the word smithing, 10, 11, and 12 with the word smithing that we've discussed. Okay. All right, now we're going to move on. How are we doing for time? We're doing okay. We're going to move on to there were reasons for opposing this recommendation. And go ahead, Representative Cardone.
I think at this point, since Judge Crockett is going to file his separate report or description, I think we should leave out the opposition reasons. That seems to me to go along with what Judge Crockett wants to articulate.
Okay. Everybody okay with that? Seeing nods. Anybody concerned about that? Nobody wishing to speak. Okay. So now we'll go on to page 3, the registry recommendations, preserving the county register of probate system. And I'm just going to start going down through there are 5 points. The first one is the registers provide unique services and that there are no analogous positions in the judicial branch requiring additional time to determine how best to preserve those features should the offices eventually move to the judicial branch. Are members of the commission comfortable including that? Is there anyone who has concerns or would like to suggest any wordsmithing?
May I ask a question?
Go ahead.
My question is to Kathy Ayers. Kathy, are you satisfied with the descriptions and the wording in that in terms of the registry services? Oh, you're muted.
I'm muted again. Yeah, I have no problem with the wording here.
Okay, I wasn't suggesting that you shouldn't be. I really did want your input on the specific language. So thank you.
Okay, the second one, given the circumstances that led to interaction with the probate court, it's essential to retain local registries rather than consolidating across counties in a way that's less convenient for the public. How do commission members feel? Do we feel that it's necessary to include that or beneficial to include it as a rationale?
I think it's perfect. It's the nail on the head.
Thank you for that feedback. Are commission members okay keeping that in? Anybody concerned about keeping it in? No, okay. 3, it would be extremely expensive to move the county registry system into the judicial branch at this time.
I'm okay with taking that out. As Judge Crockett has pointed out several times, we really don't know what that cost is. If I were a betting person, I would bet that that's true, but I don't know that for certain. So I'm okay taking it out.
Everybody, okay, we'll take that out. Number 4, although concerns have repeatedly been raised about part-time and elected nature of probate judges, similar concerns have not risen regarding the nature of the register positions. And I kind of feel like we should not include that. I feel like it's not.
I can go.
Yeah, okay. Number 5, the cost of integrating the probate court case management system with the judicial branch's case management system is likely to be high, quite high, that we should wait until the judicial branch system is fully deployed. Do we feel that it's important to include that, Justice Gorman?
So I don't know that we need to talk about the cost, but the complication, as Kathy continues to remind us, the historical records currently kept by the probate courts are owned by the counties, and we have not yet even begun to think about how that transfer could happen. So it's more the complexity than the cost at this point. It's something that should be noted, but I don't know that we could even begin to think about what the dollar figure would look like.
So if we change it to say the complexity of integrating the probate court system is significant or will be significant instead of quite high, does that cover it? And are commission members comfortable including that as wordsmithed in as a rationale?
Yeah, as wordsmiths, is likely to be complexity and maybe significant instead of quite high.
Anybody have concerns about including that? Not seeing any. Okay. Is there anything additionally that commission members would like to add as a rationale under the registry recommendation? Not seeing any. Okay. And again, we did have some reasons for opposing the recommendation, but since we're taking a different approach on how we're using the rationales, we're not going to go into those. The next gray box is the section of the plan that has to do with the court-appointed professionals. And the recommendation is essentially to recommend that the Maine Commission on Indigent Legal Services establish the qualifications for attorneys appointed by probate judges, and that these appointed counsel be incorporated within the indigent legal services system. And I don't want to read the whole box because we've all read it, but I will just move on to the rationales. There's 3 of them. The first is the need for uniformity regarding qualifications and training of court-appointed professionals across the state. How do commission members feel about including that? This is legal defense or defense attorneys for indigent persons whose rights are being addressed by the probate courts.
I'd like to keep that in. I'd like it to say need for uniformity regarding the qualifications, comma, payment or compensation or whatever you want to say, and training of court-appointed professionals across the state. And then leave out number 2. I don't want to be slandering any lawyers here, or I'm not even sure. We were just unsure how all of the counties were paying attorneys. We know some were paying consistent with MCILS, but we're not sure of all. So I think if we added the payment criteria to number 1, there's no need to include number 2.
Commission members, how do we feel about that? Is that acceptable? I'm seeing some nods. Is there anybody who's concerned about including number 1 as wordsmithed? Not seeing any concerns. With regard to number 2, Representative Cardone has proposed eliminating it. Is there anybody who is concerned about eliminating it? Is everybody okay eliminating it? Number 2, okay. So we will eliminate number 2. And then number 3, this proposal avoids a situation where counties are required to pay the costs of attorneys, guardians ad litem, or visitors appointed by state judges. I know this is something we actually spent a fair amount of time considering and addressing. How do commission members feel about including number 3 as a rationale?
I don't think it's necessary.
Actually, I do think it's necessary from a budgetary perspective. When this is going to be something that the counties are going to want, and I want to make sure that I've got a rationale for protecting it in the budget process and not have this part of it stripped.
Other thoughts about item number 3? Justice Gorman, how do you feel about it now that you've heard?
I defer to Representative Cardone, who's going to have to shepherd this through the legislative process.
Okay, thank you. Everybody okay with number 3 then? Looks like it. Any concerns? Okay, so we'll keep 3 in. And then we move down to the final point, which is I think it's the final, nope, next, yes. The 3-year review. The commission recommends that the new system be thoroughly reviewed 3 years after it has been implemented. And then we included a number of items that we specifically wanted to be reviewed. And so I'm just going to go down to the 4 rationales and walk us through each one. The first is, although the commission strongly supports the full integration, it's essential to allow the changes proposed in this report to be implemented and data to be collected on various aspects of the new system before proposing further changes to the system. Do we have any reactions to including, excluding, or modifying that? Are people comfortable including it? Okay. The only suggestion I have is the last line where it says, before proposing further changes to the system. I would suggest that we consider that before considering further changes to the system, rather than proposing. Are people comfortable with that language change? Before considering further changes? Thank you. Okay, number 2, given the distinct roles of register and clerks of courts, it makes sense to develop a long-term plan for integrating the register function into the judicial branch. Do we, how do we feel about including that? I'm seeing Judge Mitchell and Justice Gorman seem like they're in agreement on that, so that's a good start. Are others, do others accept including that? Okay, it looks like that is. And are there any wordsmithing suggestions on number 2? Not seeing any hands up. Okay, we'll move on to number 3. This talks about the jurisdictional overlap between the probate and district courts. And it goes into the Home Court Act and talks about it will be important to consider whether to reallocate jurisdiction among the courts after the new probate court system has been established. I personally, that gives me a little bit of heartburn just because it's so, it gets so ahead of where we are right now with the plan. So I would be in favor of not including it. Are others okay with that? Okay, good. All right, so 3 is out. Number 4, one legislature cannot bind a future legislature. However, even if the 3-year review does not occur as recommended, the probate court system proposed could continue. How do folks feel about including or excluding that? Did you have some thoughts, Justice Gorman?
I don't think we should suggest that it shouldn't be done. And this is a suggestion for it not to be done.
Okay. Everybody good with excluding it?
Yes.
Okay, that seems, okay, so to recap, under this last section, we've included 1 with a slight wordsmith, and then 2 as written, and then we're not going to include 3 and 4. Is everybody comfortable with that? Any other rationale that folks would like to propose be included? I am not seeing any. Okay. Thank you, everyone. I was concerned that going through the rationale document would be really challenging, and it seemed like we were, once we had our initial conversation this morning, that we were able to go through it pretty smoothly. Thank you, everyone, for your contributions. And so that brings us to a different place in our agenda than we expected to be. We thought we were going to start the day discussing the transition plan, and we kind of changed our approach and addressed the rationale document. So it's almost time for our lunch break. And I guess what I would suggest now is that we do take our lunch break, we reconvene at 12:30. And at that point, we talk about the transition plan, and then we move into reviewing the outline of the draft report. Does that seem like an appropriate approach to everyone? Okay. And I want to thank everybody this morning for this great conversation. And we will resume at 12:30. And please, if you're remaining logged in, just remember to turn off your camera and your audio, because the live streaming will run while we're taking our lunch break. Thank you, everyone. Hello, everyone. It's a little bit after 12:30. Thanks for being so prompt. It was kind of nice to have an extra 5 minutes for lunch today as compared to our other meetings. Thank you all for the great discussion this morning. We're back and under our adjusted agenda, we are next going to turn to a presentation of a plan for transitioning to the new probate court system. This is something that Representative Cardone and I put together just as an initial starting point so that we had something to discuss and modify as we move forward. And Janet and Sam are going to present it. And I think, are you planning to screen share? Yes. Okay, so they'll screen share and take us through the initial draft, and then we'll have a group discussion.
Okay, hopefully you can see my screen now. I think it's up there. I'm just showing you this initial page for today's commission meeting, just to remind anybody who might be watching over YouTube that these documents are posted online on the commission's website. So the proposed transition plan is here, the second bulleted point. And we put at the top of this document at the request of the chairs, sort of a chart format to show you where the judges terms would end and at what time across the state, and then compare that to the court region, because that was a question that was raised at the last meeting. So as you can see, the shaded areas are the counties where the judge term ends in 2022 at the end of the year. And then the non-shaded counties, their terms end at the end of 2024. And by terms, I mean the current sitting probate judges' term for which they were elected and are currently in office. That's when it ends. So as you can see, some counties, obviously, York and Cumberland, which only have, some regions, which only have one county in them, the term will end at a specific date, and all of the judges in that county, because there's only one judge, will be turning over at one time. But there are some court regions where there are multiple counties, and sometimes, as in Region 4, both of the judges are on the same schedule, but at other times there is some difference in when the judges within that county will have their terms expire. And that was important information as the chairs wanted to develop a plan for how to switch from the current county-based system to the state judge system proposed in the recommendations that you've been discussing this morning and at the last meeting that were voted upon. So the first aspect is what to do about the judge transition and about the staff that are there to support those judges. And the chairs proposed that when the terms of the 7 current county probate judges expire on December 31st, 2022, for those 7 judges, they will be replaced by 5 appointed state probate judges whose terms will commence the following day, which is January 1st of 2023. One of those will be designated as a chief judge by the Chief Justice of the Supreme Judicial Court. So that's the proposal from the chairs. There are some unresolved questions that, I think that the chairs want your input on their proposal, but also these additional questions. Will those judges be assigned to certain regions, since there, as you can see, is a difference in what regions are affected by the judge turnover at the end of 2022? Or will the regional assignments wait until all of the other 9 judges are, all of the 9 total state judges are on board once every one of the probate court judges who are currently sitting have turned over? The next unresolved issue is how many support staff are needed for this cohort of 5 judges, which includes a chief judge. So that may affect how much support staff you have, if you have a chief judge or you don't. So in terms of law clerks, judicial administrative admins, marshals, and other administrative staff. And then an additional question that hadn't really been raised before, but that did come out of the chair's discussion of a proposed transition plan, was whether there was a belief that there might or might not need to be some staff created in the judicial branch prior to the initiation of the new state judges to help the judicial branch prepare for that transition. So is that something that current judicial branch staff can help work on, or is there a thought that you might need some advanced staff to help plan for that eventuality? Then after that first transition with judges, there will be the remaining 9 county probate court judges whose terms expire at the end of 2024. And they would then be replaced by 4 appointed state probate judges whose terms begin again the next day, which is the beginning of 2025. Apparently, I cannot count and add 1. So please forgive me for that typo. But this will bring you up to the 9 total state judges that are called for in the recommendations. Again, because we now have 4 instead of 5 judges, you don't have a chief judge in this cohort. How does that affect how many staff you need? And the final question is one that was very interestingly raised. I think it was originally by Judge Crockett, and the chairs wanted to capture that question and pose it to you, which is, what happens if one of the sitting probate judges who's in this second cohort of turning over resigns early? Are you going to replace them? How many of them would have to resign early for an additional state judge to be needed? Do you want to prepare for that eventuality, or do you have any thoughts on that? The next part of the transition plan deals with the court-appointed professionals. As far as attorneys, the chairs proposed that beginning in January 1st, 2023, when those first 5 state probate judges start, that MCILS would assume responsibilities for selection and funding of all constitutionally required or statutorily required counsel, whether they were appointed by a sitting county probate court judge or a state probate court judge. So it would just be a shift of all of the probate court judge appointed attorneys would go over to MCILS. So it wouldn't depend on which judge is sitting in that county at that time. As far as guardians ad litem and visitors, the proposal is beginning when that first cohort of 5 state judges starts. When the state probate judge appoints a guardian ad litem or a visitor, then the main judicial branch for whom those state probate judges work would bear the responsibility for paying the fees. But if the guardian ad litem or visitor is appointed by a county probate judge, then the county from whom they are paid would retain the responsibility for paying for the guardian ad litem or visitor. And then beginning when all of the judges have transitioned over to the main judicial branch, at that point, the main judicial branch would be responsible for all of the guardian ad litem and visitor fees. Just to clarify something so that you don't think I'm speaking out of turn, it's not that every guardian appointed and every visitor appointed in a probate court is paid for at state expense. It's only when they are having to be paid by the counties currently who's going to be responsible. And I think the chairs proposed that responsibility follow the judge. So for whomever the judge works is who is going to bear the responsibility for payment of those fees. And then they wanted to point out that there may be other things that the commission members feel is important to specify in a transition plan. And they are certainly open to those things being added. So they didn't want you to think that these are the only topics that can be discussed in the transition plan. So that's why the other is listed here. I'm done.
Thank you, Janet. So where to start? I think we'll start at the top with the judge transition, but before we do that, does anybody have an additional item to add to our list of things to discuss? If you can just give me a word or two, and we'll put it down there so that we have a placeholder. And if nothing comes to mind now for anybody, that's fine as well. Okay, I'm not seeing anybody with additions to the other column for now. So turning our attention to the judge transition and staff. Let's look at it big picture first. We've got 5 judges will come on board in January 2023. and then the remaining 4 in January 2025. Let's talk just about that, the big picture, the staged implementation. Do commission members have concerns or thoughts to share about that? Go ahead, Representative Cardone.
I have a question, and maybe Judge Mitchell, Judge Avantagio there? Yeah.
He is.
Yeah, he is. Maybe you can answer this. The people who are, I'm concerned about judges having to run for election again while this bill is pending. And so next year would be those 7 seats that are up December 31, 2022. If we are going to modify those terms in any way, when does this bill have to be passed? I don't, maybe that's a question for the Secretary of State's office, but you know, can these people be running for election and then in June or May, or whenever this bill is passed and becomes law, assuming that it does, we tell them that they're already on the ballot, but we tell them that they're not going to be running. Can we do that? Does anybody know?
That's above my pay grade, and Justice Gorman won't give you an advisory opinion on that.
Go ahead, Judge Crockett.
When one of the counties had to consolidate their register of deeds positions, I think it had to be done in prior to January 1st. I thought that's what, and I'm just winging this, but one of the counties went from 2 registers of deeds down to 1, and this was only 3 or 4 years, 3 years ago. And I think it had to be done before January 1st. So you'd have to have, wow. Yeah, I don't know if you'd make it, but I think that's what the legislature did. And you were probably on judiciary when that happened. But it was Oxford County went down from 2 registries to 1. But I think that was it. And I can't remember the exact wording to it and why, but so you're looking at a 2/3, you have to have a 2/3 vote to get an emergency enactor on this.
Right.
Well, good luck. Okay.
Okay, that is obviously something that it would have been smart for us to research ahead of time, but we will definitely look into that concern. Other concerns or reactions to the staged rollout, stage implementation? Go ahead, Judge Mitchell.
Perhaps this plays into the, perhaps this plays into the other discussion we were having, but I'm a little concerned about, we have already set aside for delay. We're keeping the registers in place because for policy reasons as well as for cost, but often major, I think one of the reasons is policy. So we've got a hybrid court out of the gates. And then you're going to have the judges all halved up. And that doesn't matter in a place like Aroostook or York or Cumberland when there's a single judge. But I look at Judge Avantagio's district, there's only 1 judge that's going to be replaced there. So how do you envision this working? And again, I'm a little concerned about the perception. I want to start as you do, because that's our recommendation. But I sort of wish it could be a wholesale, at least transition of the judges. And I know we have the constitutional barriers. You're elected to a 4-year term. So what would happen if they all took place in 2024 and we got all the preliminaries done? It's just a thought. I don't even know if I support it. I just wanted to get your reactions to this mixed bag of some state probate court judges and some county elected probate judges. And what's a chief judge going to do to the county elected probate judges? I mean, it just raises all kinds of questions. And we're all working in good faith here. And this really is a question of concern, not of, I have no answers. I wish I did.
Go ahead, Representative Cardone.
I agree with you that that would be neater if we could have them all come on at the same time. My concern is that if we do that and we can't modify the current terms coming up, we might not have anybody coming on until 2026. And I'm really concerned about the funding. I won't be here. I'm really concerned about any of this ever getting funded if we're pushing it out that far.
I wasn't suggesting that everything stopped. And this is another question that might require the Secretary of State, or certainly perhaps Justice Gorman could help me. Is there any way that it sort of takes effect, shall we say, in this coming year, but those judges who are up, shall we say, could be appointed? No, I can't. I guess this county you can't. Could somehow their term be extended for 2 years, and then boom, they're all gone. Again, I'm just exploring options because it's complicated.
I don't really have an answer to that, but that's an interesting suggestion. Like, when does the constitutional provision, when is it revoked vis-a-vis creation of the replacement system? We need to look into that. I did, Judge Mitchell, also want to respond to the question you raised about what's the authority of the chief judge vis-a-vis the judges who remain elected. And I think that the chief judge is in many ways going to be responsible for helping to set up and establish the new state probate court, and would have authority relative to the state judges and be preparing transitionally for the other judges who will come on board, but wouldn't have direct authority over that other judge until the other judges became state judicial branch judges. So I think that's the role of the chief judge. I wanted to address that. Someone had a hand up and I missed. I think it was Leo. Go ahead.
Yes, thank you. I just wanted to address the issue of the election of the judges that would be affected when their term expired next year. And that depends on when the constitutional amendment is triggered. I think it gets triggered once the legislation becomes effective. And theoretically, that has some practical issues with respect to running for re-election. But the bottom line is that the legislation that creates this new system could, in fact, allow them to run for a 2-year term. So if they ran for a 2-year term, then their term would expire at the same time as the other 9 judges' term expired. So theoretically, I think it would be possible to have everybody's term end at the same time. But like Representative Cardone, I'm mindful of the difficulty, the budgetary difficulties that this particular proposal is going to have to deal with. And because our financial position is now sound, I think that this legislation has a better chance of passage than in other years when our financial position has been less than good. But the practical problem, I think, is if you're going to run again, your term is expiring and you're going to run again, when do you start running? And can you, in fact, run conditionally so that, you know, once the statute is, once the law is passed, assuming it's not an emergency, it won't be passed as an emergency, and the effective date becomes sometime in the early fall, what happens to your
We lost him again. I'm sure that he will be rejoining us momentarily to finish what he was saying. I also did want to raise, you know, another transition issue is the need for the judges to be reviewed and nominated by the governor's nominating committee, and then have a judiciary committee confirmation hearing, and then a vote by the Senate. So there are certain things that are going to take time in conjunction with this transition. If Judge Mitchell, when you are running for probate judgeship, or Judge Avantagio, when you're running, when do you start your campaigns? That might be a good piece of information for us to have.
Without raising hackles, we are, except for Somerset County, which has a charter which says you're independent, we run on the ballot as a party. So there's a primary. So you have to get on the ballot, even though there's maybe no one running against you, and often there is not. You have the same time constraints that you do as a state senator in terms of having to get on the ballot. Perhaps, and also what I was thinking, state judges do have to be nominated and vetted and approved by the Senate. And these would be in that same category. That's another time thing, which adds to my concern about starting before we're ready. Because what is the earliest that you could pass? I mean, let's assume that you can get a majority of the legislature. It's unlikely you'll get 2/3. I mean, we've heard Senator Kimes' opinion, and we've heard Judge Crockett's opinion. So the best probably you could hope for is a majority. And you're not going, this is what you'll adjourn by when, April? I don't know, but it won't be put into place. And so that's what I'm concerned about too. It's not just, and you pointed that out so well, I hadn't even thought about that, the vetting and the appointing of these new judges, which is, and then of course, people who want to run again, and I don't know who they are. I mean, you can look at this list. Some people may not have planned to run again anyway, but if they're going to, or their replacement is going to, we're stuck with the primary initial getting on the ballot. And Will, can you add to that?
Not particularly. I think the question was, when do you start? I had to do it in the last go round. They have to get the paperwork to start collecting your signatures, and those have to be submitted by, I think it was March 15th if you're affiliated with a party. It was later than that if you're not. So really that much of the process, at least the gathering of the signatures, as soon as you can get the paperwork done in January to have time to do that. The campaigning itself, I just didn't do. I'm not a politician. I don't want to be a politician. I didn't speak to groups. The first round, I didn't have any opposition, so I didn't have to do anything. The last round, I got some signs and put some signs out. So my campaigning wasn't existent. So early January of the year is, I think, the answer to your question. When does it start?
Thank you. That's really helpful information. Go ahead, Representative Cardone.
It seems to me then, given the timing of this and also given the timing of the budget process, that if we can do what Leo suggested and have a law that takes effect, even if it doesn't take effect until July, August, September, whatever it is, have a law that takes effect that says this next election cycle, the term is going to be 2 years. And then this whole thing takes effect December 31 or January 1, 2025. That would give us the budget cycle to try to put these, I'm tongue-tied here. That will give us, we won't be looking at a supplemental, we'll be looking at the biennial budget to try to get this into place. I just don't know if we, I don't know if we could do that. Otherwise, I'm afraid we're going to be pushing this out 6 years. And I don't like that, or 5 years.
I wonder too, if it would make sense to consider appointing the chief judge much sooner so that you would have somebody who was setting up the systems and getting ready for the implementation, even if we had to delay the implementation to 1/1/25. Leo, we lost you mid-thought and invite you to continue where you left off.
Yes, I'm in an undisclosed location now. Had to move everything, and I apologize again for any disruption that I've caused. I don't remember what I was saying, except that I remember that the general subject was the transition and how that it might affect somebody's candidacy and the timing of it. And I literally not heard anything since I was stopped in mid-sentence.
I can give you a quick catch up if you'd like.
That would be wonderful, but I don't want to hold everybody up.
No, just in a nutshell, we kind of took the conversation where we lost you, and we got some feedback from Judge Mitchell and Judge Avantagio about running for re-election, and that would actually start in January of 2022. And so from there, we returned to your suggestion that perhaps it would be possible through legislation to change the terms for those running in 2022 to a 2-year term. And that's essentially where we are now.
Yeah, I mean, I think that's absolutely possible. And again, as I was saying, that the only disadvantage of doing it that way is that you end up beyond a point where you can forecast what the economy is going to be and how difficult it's going to be to actually get the money to fund something that's already been passed. So it would be best if we could get it started in next year. And the idea that you'd have a mixed system is awkward for sure, but this is a very, very difficult transition. And I think we're just going to have to get used to the idea that it's not going to be perfect. And we're just going to have to do the best that we can for a relatively short period of time. I mean, 2 years historically is nothing. And I think everybody, if they act in good faith and continue the traditions that the probate court has projected over the years, I think we'll be okay.
Thank you. Can others weigh in on this thought about the 2-year implementation and the suggestions on the table? One is to delay everything to start on 1/1/25, or to include in the legislation, the change that judges running in 2022 would have just a 2-year term. Go ahead, Justice Gorman.
So I'm not giving an opinion on the constitutionality of Leo's recommendations. I will simply assume that he is accurate for the purposes of this conversation. And I'm just going to suggest that we think about a compromise. In region, what we refer to as Region 2, which is Cumberland County, and Region 7, Hancock and Washington. The terms of those judges are all up in December of 2022. We could start with a chief judge and 2 full-time appointed probate judges in those regions and allow the other regions that have what I'll refer to as a sort of mixed bag, allow the judges who are serving, who've been elected to serve until 2024, stay until 2024, and those who were elected to serve until 2022, again, assuming Leo is correct, can then be elected for 1 additional 2-year term. It would still be the awkward transition of half in and half out, but it would be a cleaner transition than trying to do it in a place like where Will is sitting, where one judge is termed out and the others are not. So it may be easier for the judges to work together in that way. And it would also give the chief judge, who should be chosen right away, something to work with, to figure out how it would work going forward.
Okay,
Yeah.
I like that.
Can we have some reactions amongst members of the commission to that proposal? Thank you, Justice Gorman.
I could live with that. I like it. I think you're right. It's less messy than these divided, going in with these divided districts. I think that could work.
It may also mean, one of the things that Judge Crockett mentioned is that, and Judge Mitchell have also mentioned, that there may be people who don't want to serve their terms out once this is implemented. And there may be other regions where we will not have to contend with how to handle judges who are still in elected office after this passes. So if the proposal looks like in a place where there are no further elected terms to deal with, this system can be implemented. And if not, it will be implemented as of the 1st of January, 2025.
Yeah, it also alleviates some of the time crunch with regard to nominations by the governor, nomination hearings and confirmations, because it reduces the volume of work that has to be done by January 1. Leo Delicato, go ahead.
Yeah, I have one additional comment, which is if one of the judges resigns or something untoward should happen and they cannot continue, I think that the Constitution would, at least presently, allow and require actually the governor to appoint somebody to serve out the rest of the term. Again, that could be a line in the legislation that would allow the governor to do that. So you would preserve that function that now exists, not constitutionally, but statutorily, for the governor when this becomes effective. I don't want to, somebody wants to resign or somebody, dies or becomes seriously unable to continue, we'll have a succession in place if we put something in the statute.
Thank you. Other reactions or comments, thoughts about this suggestion?
I won't need some clarification as to how that would work, Leo. Judge Avantaggio, you'll excuse me, but I'm going to use you as an example. I don't mean to put any pressure on you. Let's say that Judge Avantaggio, whose term is up December 31st, 2024, decides that he would like to apply for this first round of judgeships. And so he puts his name in and he's selected. So he then resigns from the state appointed, the county elected Lincoln County probate judge. What happens to that Lincoln County probate judge slot, Leo, under your example? Does it go to a 7-year term, or does it just get filled the way that it does with the governor, not to the end of 2024?
The statutory language would give the governor the authority to appoint in a resignation or a disability situation to the end of an individual's term.
Okay, but that would be a county position then, not a state-funded position.
Yeah, it would be a county probate judge's position. So I'm just trying to use what authority exists now in the Constitution for the governor to solve problems that would occur either before the effective date of this new statute or after the effective date of this new statute. So, it could very well be that in November of 2022, somebody might want to resign or be forced to resign. The constitutional provision would be gone because the statute would have already become effective.
I see what you're saying. Okay.
But you give the governor the ability to appoint to the end of the term, or assuming you've gone beyond that they can still appoint, the governor can still appoint in the same way that the governor could have appointed under the Constitution.
Okay, I understand what you're saying now.
Okay.
Thank you.
The representative's question brings up an interesting possibility, though, and it may not be that far-fetched. So since she used me, I'll use me. I resign my position as judge of probate because I want to be a full-time judge of probate. I can still go be judge of probate if I'm appointed to this district. I don't remember how the positions line up. Is there a requirement that there be another county judge of probate appointed? You may have trouble getting somebody to run, I would think, but I don't know whether we can deal with that or not. If that's something that can be, if that contingency is something we put in, or if we just leave that.
Thank you for raising that question. So we have three judges with their hands up, and Judge Mitchell, you were about to start talking when Representative Cardone talked, so I'll call on you first, and then Judge Crockett, and then Justice Gorman.
I need clarification about the proposal because we've wandered off into what ifs. And just a clarification, if the Constitution is still in effect while the legislature is contemplating and passing this bill, if I should die in office, as my husband did, he died far enough, he died in September. And so I had a full election. There was no gubernatorial appointment. So it's important to make those distinctions. And we are getting into the weeds, but that is what we're trying to do, is we're trying to blend. So it seems very complicated. And quite honestly, you talked about getting good people to run. I don't know if anybody's going to run for a 2-year term that's seen as not respected and is gone before you even start. And frankly, it takes you about 2 years to learn to do a good job anyway. So you've got these people now who will be elected to 2-year terms who may have no hopes of they're not going to be 16 probate judges anymore. So this is why I'm so worried about why don't we just do it at the same time? And I know you don't want to wait because of the money, but if this has merit and we put everything in place, I don't know, Leo, you may be right. I've certainly been a former legislator and there may never be enough money, but if it's good enough, I don't know. But I am concerned about this hodgepodge relationship of appointed judges here, elected judges there. And is that the best way to transition? And you're right. I think Will's regional district is a perfect example. There's only one judge there who is up in the next term around. And that leaves 3 counties. And where would that go? If Will was appointed, would there be another person appointed to do Lincoln County until that region came online? So those are just questions, but primarily I need to understand exactly what Justice Gorman was proposing because I wasn't totally clear on it.
Thank you, Judge Mitchell. And my apologies, Judge Crockett, but I'm going to let Justice Gorman restate her proposal so that we're all back on the same page, and then you'll be up. Thank you.
I feel a little bit like Libby sitting in my chair at oral argument, and now I have to respond to her. But my proposal was pretty simplistic to begin with, and now we're talking about the complications that happen with regard to terms that would end at about the same time that this is implemented. And one way to get around that would be to appoint 4 judges right out of the box, one of them being the chief judge, and the other 3 identified as filling what I'll refer to as Region 7, which is Hancock and Washington, and Cumberland County, and any other county where there is no longer an elected probate judge. So like the first Superior Court judges and even the current ones, really, they'd be riding the circuit to a certain extent, but they could, because they would have statewide jurisdiction, be able to fill in those counties. They would also have the benefit of learning the job from the currently elected judges, which would be a great benefit to the newly appointed judges. And they would also have the benefit of figuring out how to work with registers from those currently elected judges, which again would be a tremendous benefit. And then they could pass on what they've learned to the next group of appointed judges. So maybe, I know it would be messy, but it might also be more effective and efficient than having a whole new slot of appointed judges, especially if they were not, that the current slate of elected judges didn't ask to be considered for those positions. So that's my slightly amended response at oral argument to Judge Mitchell.
Thank you.
And I think that's pretty close to what Ann and I were talking about when we proposed this. I think we were talking about 5 instead of 4 judges, but I think that's pretty close to what she and I were thinking. And I'm sorry, I don't want to cut in on Judge Crockett.
I was just going to say, it's I feel like
Well,
the
if I'm going to be
referee here.
cut
Go
in by
ahead, Judge
Representative
Crockett.
Cardone, you're my first choice. So I guess I have to pose another question to Justice Gorman. So what happens in a situation where you have an elected judge? Can they also be appointed as a chief judge? Let's say you had Piscataquis County, where District 5, his term ends in December 31st of 2024, and he's a well-qualified attorney. He wants to be the chief judge. The governor agrees. Can he still maintain that position, and then when his term expires, be filled by, because right now his position is part-time. So can they be dual-hatted?
I guess it's not clear to me what you're asking. From my point of view, the judge of the full-time, the chief of the probate court is going to be more than a full-time position. But like the Superior Court, especially initially, there's going to have to be some cross-pollination across the regions and across the counties as to where they sit. So if the current probate judge from Piscataquis County wants to be considered as the chief judge and he gets the nod, I don't see what the problem is.
So does he have to resign as his county position to take the state?
Yes, yes.
I was going to say, 'cause it would be very convenient if he was dual-hatted for both, given the amount of court days, but yeah.
Go ahead, Representative Cardone.
Yeah, I mean, the way that at least I was looking at this chief judge, the chief judge would be somebody appointed by the state judiciary, just like the chief judge of the Superior Court and the chief judge of the district court. I don't know that the state judiciary would have the power to appoint a county judge as a chief judge. I think they would have to be a full-time state employee to be the chief judge under this legislation that we're proposing. That was at least my understanding of what this said.
But I thought it was, this chief judge will be a roving judge with no geographic affiliation. Is that correct? That judge will be appointed without geographic affiliation? Is that correct, Justice Gorman?
Well, I mean, that's one of the questions that's further down on the list, as I understand it. And as Representative Cardone pointed out, our former Chief Justice was always very clear with the Judiciary Committee that she would like to be able to decide where to send her judges. On the other hand, we do have to be mindful that if every new judge is appointed out of York County, that will be a problem. So geography does make a difference, but we have to make sure that we have enough judges to cover the state.
And I think, regardless, Judge Crockett, if someone is applying to be the chief judge of the probate court, that would be a full-time state court judicial position and would be their exclusive judicial position.
Well, and I'm not sure anybody puts in an application that says, I want to be chief judge. I mean, you put it in an application to be a judge of probate. You get nominated and confirmed and sworn in, and then the Chief Justice, I think, isn't Justice Gorman, am I correct, says, you're the Chief Judge.
Yes,
if that's how.
There are no applications for that. In fact, most people run from that.
Okay.
But this would be a full-time position that wasn't geographically affiliated. So I used the word chief judge, but you could be that roving probate judge. And so that's why, forgive me about using chief judge, but the full-time roving judge can't be a county judge as well. That's what I wanted clarification on.
Correct. I mean, what we had or at least what I had envisioned is that there would be at least one resident judge in each of the districts, although we haven't really specified that, but we talked about one judge assigned to each of the districts. But the chief judge is the person who would be doing the scheduling. So that would be someone who could cover then where is needed. But again, I was kind of leaving that to the judiciary.
So let's go a little bit further down, because this has been a really great discussion, and I think that the suggestion that Justice Gorman made about numerically changing the transition plan makes it much more workable. So let's just proceed down and have some discussion about the unresolved questions. So let's skip over the first one because we've talked about that a little bit. So say we have a cohort of 4 judges initially, which includes the chief judge. What sort of support staff do we think would be needed for those 4 judges? And Justice Gorman, are you able to help us out on that a little bit?
I am, but I'm going to ask Catherine to back me up on this because I can do part of this, but I think some of this is going to go to her. With regard to law clerks, I would say for the total complement of judges, ideally we would have 2 law clerks. So 1 in the first batch and 1 in the second batch. We would need probably 2 admins, again, 1 in the first batch, 1 in the second. And then we need a marshal for every judge. And then with regard to facilities and IT, Catherine, I'm going to ask you to spitball that.
So I think that we would need 1 of each, and I think that they would have to be upfront. So I think that they would need to be at the beginning, in the beginning group.
So that would be 1 facilities manager and 1 IT staff person?
Yeah.
Thank you.
Justice Gorman, how does security work if a judge is moving from building to building?
So the security is really attached to the building more than to the people. For example, now that we're no longer doing entry screening for COVID, we've gone back to having entry screening in some of the buildings. And in the places where there's not a judge sitting that day, we don't always have entry screening, but we try to always have entry screening in a building where there is a judge. And then there would be a marshal assigned to the courtroom. That's our sort of our bottom line security plan. So we would really need one marshal, one additional marshal for every additional judge.
Gotcha. But I understand the 1-to-1, but can you have a marshal be in Wiscasset on Wednesday, Knox on Thursday, Rockland on, or
Yes.
Baltimore on Friday? Yeah.
Our
Okay.
marshals are assigned by regions, and so they do travel with the judge for the most part,
Got
or
it.
travel to where the judge is sitting that day.
Thank you.
Thank you. Thank you very much, Catherine and Justice Gorman. So the next question is there any staff that would be required during calendar year 2022? So before, if implementation began with judges taking on their new roles on January 1, 2023, do we need anybody before then?
The only one that I would suggest is IT, because we are going to have someone take a look at what systems the probate judges are currently using and the registers are using. And although we certainly cannot come up with a cohesive plan for how to use it, we should at least be familiar enough with them that the first day on the job, the judge is not completely stymied with what's happening.
Okay, thank you. So as soon as the legislation went into effect. Great. Thank you. Judge Crockett?
So for the IT question, is the state envisioning renegotiating with ICON so the IT person can gain access to it? Because I think the current contract with ICON is between the counties. So is that part of the transition plan? The state's going to end up renegotiating and taking on that?
I can't speak to that. I can only say that the choice that we went with was Odyssey. And so it is more likely that Odyssey would be enlarged to take over the probate system, I think. But that's as to adopt something that Will said earlier, that's above my pay grade.
So, but
And I
the
think
transition
just-
plan for
Just
the state to have
to,
access needs to have some sort of access to ICON, the existing system during the transition though, right?
Yes.
Okay, so there will be some renegotiation. Okay, thank you.
yeah, and I think one of the questions for the 3-year review was to take a look at, because initially it's contemplated that both systems will continue to exist and cover the probate court on the one hand and the rest of the judicial branch on the other, and that those changes would happen in conjunction with future planning. Janet, go ahead.
I just want a clarification. Sam and I checked and we just were not entirely clear. So originally Justice Gorman had said that there would be 3 judges. I understand it's now 4. But is it still the case that only the Cumberland County, Hancock County, and Washington County probate judges disappear as county offices on January 1st, 2023? And the other ones that were shaded in gray because they end in the end of 2022 become 2-year elected terms? And we just now have 4 probate judges and state probate judges instead of 3. I just wasn't clear because we both thought that was staying, but some of the discussion suggests other people think otherwise.
Thank you for raising that. Justice Gorman, go ahead.
So I think, Janet, I think you've got it right. Again, we're assuming that Leo's constitutional evaluation is accurate and that there can be a creation of 2-year terms for those judges. And if, as what Judge Mitchell pointed out, people may not want to run for those, it may be necessary to, at that point, identify 2 or 3 other slots that occur in the first iteration of full-time appointed probate judges.
Thank you.
Thank you. I'm going to call on Judge Mitchell first.
Oh, yeah.
Go ahead, Judge Mitchell, and then and Representative Cardone.
This discussion has been very helpful, and your oral argument was very persuasive, Justice Gorman. If it also is persuasive, Representative Cardone's plea that we move while we can, and I also like action rather than talk. And so I think with Justice Gorman's proposal, this works. And the details, the finer details of how we deal with phasing in the rest of it, we started to get into that. But as an overarching thing, that proposal works because those counties are already ready to be transitioned. And so I don't know if everybody feels that way about it, but if they do, then we need to sort of polish, if you will, what do we do while the legislature is doing its job and vetting this proposal, and how that impacts those people who are waiting to find out what's going to happen to their lives. But I just wanted to say, I get it now, and it makes sense to me, Justice Gorman. Thank you.
Thank you. Go ahead, Representative.
In the discussions that Senator Carney and I and our OPLA analyst had with Maureen Dawson, who is the OFPR analyst for the AFA committee, for the Appropriations Committee. One of the things that she suggested is, and this makes some sense, and so we have a little bit of leeway here. One of the things that she suggested is if we're not sure exactly how many judges we're going to need, we could ask for and try to fund more judges. I mean, maybe we ask to fund 6 positions. Maybe we ask to fund all 9 positions and see if we can get all 9 funded. Even if we decide we don't need them, then we come back, you know, we've got a surplus and that can carry over. What we can't do is if we only fund 3 positions and then 6 people resign, we can't go back and appoint more than 3 judges. So I don't have a problem with arguing for more positions to be funded than we think that we can fill, just for that reason, because we just don't know how this is going to shake out.
Go ahead, Justice Gorman.
So with what Representative Cardone just said, we should ask for funding for 9 and then use them as we need, because it may be that there are currently elected judges who in fact want to be considered to be appointed full-time judges, and so they will resign. Or there may be others who decide that they no longer want to work in this kind of a system, it's for whatever reason, and they will too resign. And unless we fund 9 judges now, we may really have a problem in terms of not having enough judges.
Thank you for those observations. Judge Crockett, is your hand up anew or residual? Okay, thank you. Other comments and thoughts on the number of judges before we move on? We've had a great conversation. I feel like it's important for us to address the other issues on the next page. Okay, all right, we'll move on to, and these, actually, I think we've kind of already addressed these now that I'm looking at them a little more carefully. So we've identified that we'll need in, say there's 2 implementation phases. We would need 1 additional law clerk, 1 additional administrator, 1 marshal for each judge, and that we would not need an additional facilities manager or IT staff, but that the employees, the staff from the first wave would satisfy the need. And then we actually have had a kind of a robust conversation about probate judges, county probate judges who might resign or otherwise leave their positions earlier than December 31. So I think what we've got now, I think the question we need to answer is, can we draft legislation that will allow us to basically, as terms and either if, as terms end for reasons other than the expiration of an elected term, can we draft legislation that will enable us to transition those to state judges that are appointed through the normal nominating and confirmation process? And I don't see any obstacles to that. Are there any other additional reflections on the phase 2 implementation aspect of this plan? Go ahead, Justice Gorman.
I guess I'd like to ask the probate judges. No, I'm not asking you to identify, but do you have a sense that if this in fact passes, there will be a mass exodus, either because judges don't want to be part of a system that's about to be ending, or because they want to join the new system? Should we be prepared for larger numbers than what the election timetable would cause us to believe? If
I
you
don't
know.
have it. Yeah, I don't know. I haven't had those conversations with folks and haven't much thought about it myself, but it certainly seems like a possibility. Yeah. Would the process be that a sitting elected judge has to resign to be considered, or could that judge be considered, approved, and then resign? And that may make a difference.
Yeah, and I don't know of any prohibition of having, well, I mean, right now, let's assume that there was an elected probate judge who wanted to be a district court judge, who put in their application. I don't think you have to resign until you're actually either confirmed or even maybe sworn in. I don't think there's anything, unless Judge Crockett knows something different, I don't think there's anything preventing a current elected probate judge from doing that. And I would think this would be the same way. Judge Crockett, do you know differently?
No, actually, that's a true statement. In fact, Justice Crowley was a probate judge when he was appointed. And then Judge Cabot from York became a workers' comp. He was, I think he's a workers' comp judge now, or whatever that system has. So he was an active probate judge, then he resigned and so forth. So that was one. Number two is, there was a question posed earlier. In this situation, I represent the Probate Judges Assembly. And I do not know obviously there's been a lot, I've been contacted by a number of the judges that are opposed to this hybrid Pinto solution. So I'm not sure if it's going to cause it. I speculate not, because so many of the judges are retired or part-time judges that I don't see where there would be a huge implication in your plan. So I wouldn't consider that an issue. In terms of that portion of the plan, I don't think that would be adversely affected. I don't think we'd be short all of a sudden. It'd be some big catastrophe. So just throwing that out there.
Yeah, I suspect that's right. I don't think you'll get a bunch of resignations in protest. I think you may get people who are asking to be full-time probate judges and then having to resign whatever's left of the term to which they've been elected.
Thank you both. And Justice Mitchell, did you want to weigh in as well?
Yeah, just very quickly, I would agree with them. And obviously, we've not had conversations that say this is what I'm going to. I can speak for myself. My term doesn't expire for 2 years, and I'm not planning to retire because I love my job, and it's a 2-year plan that I have had. And I think many of the judges are in the same position. So we don't know. It's very individual, but I'm speaking for myself. If that gives you any guidance, you're stuck with me.
That's terrific.
And if need be, if the judicial branch needs people to shift or to resign, I mean, I think it's a conversation. Most of the probate judges are they believe in the system, more so than their own position. So the good of the system would always come first, I think. So
That's nice.
So I want to make it clear, I'm not suggesting we want you to, because I truly believe that to the extent that we're going to be putting new people in positions as probate judges, we need the current judges to help them figure out what the job is actually all about. So I'm hoping that there are people like Judge Mitchell who are willing to stick around and train the new batch of judges.
Thank you, everyone. I think that, let's see. I'm going to try to summarize what we've decided on step A of the transition plan. That's the judge and judicial branch staff, that we would in the appropriations process ask for all 9 positions. But what we think would likely happen is that we would have 4 positions that would begin on January 1, 2023. And those would be 3 probate judges and 1 chief judge. In addition, we'd have 1 law clerk, 1 judicial administrator, 1 marshal per judge, 1 facilities manager, and 1 IT person. And that the IT person would actually begin as soon as the legislation went into effect. That the legislation would create a mechanism whereby if there were a vacancy among a county probate judge, that position could be filled with a state court judge through the state court appointment process. Go ahead.
Now, that's not what Leo said.
Oh, okay.
But did we modify that later? I think what Leo said is that's because that's what I was trying to get clarification on. I think what Leo said is if there was a vacancy with a county judge, like Lincoln County, that the governor would appoint another county judge for the remainder of the term, which is what the current constitutional provision is. So that constitutional provision, to the extent that that would go away, we would pick that up again in the statute. Now that I'm not sure that that's what everyone agreed to, but that's what I understood Leo was talking about.
Okay, and we actually have a choice, right? Because we could do it either way.
Yeah.
Yes.
Go ahead, Leo.
Yes, that's true. I just want to make sure that I make clear that I believe that the Constitution right now allows the governor to appoint somebody until there's an election.
Yes.
Okay, but using that as a model, I extended it a bit, and you could, in statute, after the constitutional amendment is triggered and the provision 6.6 goes away, you could write language in this statute that would allow the governor to appoint until the end of the term. So you wouldn't need another election as now. I mean, it's just in the weed stuff, but bottom line is that the governor would appoint, you wouldn't have to have another election.
Yeah. Okay, and I guess my question to the commission as a group is it preferable to have the governor reappoint somebody just to fill out the elected term, or is it preferable to have a regular appointment process? Justice Gorman, go ahead.
So I think that it would be cleaner and easier that if there were a retirement or a death or whatever within an elected term, that this legislation then allows the governor to fill it with an appointed probate judge. Now, the question is, does that automatically trigger a new appointment? Or if, I don't want to say we have extra judges, but let's say we get 4 new judges who begin January 1st, and then a probate judge retires. It's not necessary right then that a new probate judge be appointed because there's probably enough coverage within the current 4 to pick up that county, but it would depend on where the county is. If it's a county that's not currently geographically covered by those 4, it may trigger an automatic appointment. If it's one that's close by and has a relatively small docket, it may not. But I would allow for the governor to fill it either with an already appointed judge or with a new appointment, if we could write it that way.
How do other commission members feel about that suggestion? Go ahead, Representative Cardone, and then Judge Crockett.
I could be persuaded either way. To me, this isn't, this is a minor transitional point, not a huge deal, but I do think it needs to be dealt with. Because otherwise we have a jurisdictional question at this point. A governor saying, do I reappoint for the benefit of the county, or does this now automatically become a state court position? So I think it's really important that we decide and specify this point.
Judge Crockett, and then Register Ayers, did you also wish to speak on this?
I'm wondering about the judge's appointment, because the judge's appointment currently, am I wrong about this? I'm not sure. You have to go through the Democratic or the Republican Party and get the nominations from them, and that the governor's not directly to the governor.
That was my point as well, was that you have to make sure you distinguish that because of the caucus process. We went through Judge Longley, where the caucus generated a couple of names, and then the governor's committee vetted and chose one of the 2 names. But they're limited in their selection to who the political parties throw up, so you're going to have to change that portion of the statute no matter whatever option you do. So just take note of it and make sure you address it in your final legislation.
Thank you both. That's really, really important for us to know. I wasn't aware of that.
Yeah, I'm now remembering that with Penobscot County too, when Judge Woodcock resigned. Maybe we just say, if a county probate judge, there's a vacancy, retires or dies, or if there's a vacancy or something, that before the end of the term, that position will be filled by a state court judge. And then if we've got the positions funded already, then I think it's okay that we aren't more specific than that. If the Chief Justice goes to Governor Mills and says, hey, we're drowning here, we need another appointment, give us 1 or give us 2, the governor can do that. If everything's fine and it can be covered, then nothing has to happen.
All right, so how are people feeling about that the replacement would be a state court, that the replacement wouldn't be essentially stepping into the shoes of the county judge, but would actually be a judicial branch probate court judge? Can folks, if you are comfortable with that being part of the proposal, just raise your physical hand. Okay, and if you're uncomfortable with that, can you now raise your hand? Okay, so I think that is I was summarizing what we were doing with the judicial positions. So I'm going to finish. So we've resolved the issue about what happens if there is a resignation or a county probate judge leaving office. And then we move on to step 2 of the implementation, which would be for judges whose terms expire on December 31, 2024. We would need 1 additional law clerk. We would need 1 additional judicial administrator, 1 marshal per judge. We would not need any new facilities managers or IT staff. So I think that is kind of a summary of the judge element of the transition plan. Is there anything that I miss or misstated? Not seeing any hands. Okay, so we're going to move on to the transition of court-appointed professional funding. And so the way this is envisioned is that with the initial implementation step on January 1, the Maine Commission on Indigent Legal Services would assume responsibility for all constitutionally required or statutorily required counsel appointed to represent indigent defendants by either a county or a state probate court judge. Is there any comment, discussion, concern about that element of the plan? Go ahead, Judge Crockett.
Will we still have the ability, and this is unique to the probate court, I can appoint a judge to represent somebody in almost any type of case. And sometimes it ends up when we go through the indigency paperwork that the person can afford to pay. So essentially they get an appointed attorney at $80 an hour, which is very reasonable because a private attorney would have been $200. So are the judges under this new system going to lose the ability to do that? I guess I posed the question. I don't know the answer.
Yeah, I can say as somebody who takes appointed cases, it's not uncommon to see an appointment that says you're partially indigent, you're appointed counsel, but you repay the court at the rate of $50 a month up to $600 or something like that, or whatever the fees are.
But that can be
Assume
in the
they can do
case. Yeah, but here's the difference is that the way it's drafted, it says statutorily or constitutionally, right?
Yes.
I can appoint them to a guardian who's petitioning to take on a child. I can appoint an attorney, even though that petitioner isn't entitled to an attorney under the law. It's a different role in the GAL. I can still do that. Will I be able to have the ability to do that under the new, when all the appointments go to indigent legal services?
So I think I can address that.
Yes, go ahead.
You heard from Justin, and it's not that we're in a pitched battle with MCILS or a pitched battle with the legislature, but it's all about funding. Judges would love to appoint, I would say state judges would love to appoint lawyers to everyone in every case. And if the legislature would fund that, we would do it. So there are certainly, I mean, Judge Crockett, you know, from having appeared in front of me on any number of occasions, that people are assigned attorneys in the state court system, even when they're not really entitled to them because they're not truly indigent, or because it's a criminal case where they're not truly facing any sort of incarceration. Judges in the state court system have to answer for that sometimes when they get, I don't want to say audited by MCILS, but get a question from MCILS. But they still have judicial discretion when it is necessary until the legislature tells us otherwise.
Fair point. Thank you.
Thank you. Go ahead, Representative.
I'm going to go a little further. This is speculation, but Justice Gorman is talking about cases where there is at least arguably a statutory or constitutional provision that says that says you're covered, you're entitled to an attorney. I suspect if a state court judge appointed somebody to represent somebody in a divorce case and MCILS got the appointment, they would call up and say, no, sorry, I don't know about the pitched battle. But I would be concerned that if you appointed somebody in a case where there is no constitutional or statutory authority, that you're going to get a pushback from MCILS. That's just based on my work with them, that's just my thought. I don't know what Judge Avantaggio has a different thought on it, but.
No, that sounds about right. But I can also say that each year we need to put in a budget to the county for what we think the appointed needs are going to be. If I had a larger pool of funds, I would appoint more attorneys. It would make the process smoother for the people that are in it. It would make the process smoother for me, instead of trying to give non-legal guidance to people who are trying to get, as Judge Crockett said, a guardian who's trying to do a good thing for a child who needs a guardian but can't figure it out. There's only so much that I can do, even prodding the register to offer some assistance. If I had the ability to appoint an attorney and not worry about how much I had put in the budget for attorneys the year before, I would do that more often.
Thank you. Judge Crockett, Janet's hand is up and I just want to check in with her.
I just wanted to highlight here that there was some confusion, at least in my mind, at the last meeting of when attorneys could or couldn't be appointed, or guardians and visitors in these cases. And we did put together a handout on that, which is on the website, and you should have been emailed it, and it's in your packet if you're here today. And there is a provision for what Judge Crockett was saying, that if the parent has had an attorney appointed, and there is an indigent petitioner for a guardianship, then the court does have the statutory authority to appoint an attorney to that petitioner. It's sort of a cascading ifs, but there are statutes covering a lot of these things. Some of them are less than clear, at least as I read them, but I'm not as totally familiar with these as the people in the room are, and I understand that. So I don't know if that would be helpful at all. But there is more statutory authority than you might think. The narrow part of the statute is where it specifically says in statute that the court has to pay the expense. That is a very, very narrow category of cases. But the appointment power seems, at least from my not expertise opinion, fairly broad.
And I think the great treatise Mitchell and Hunt will support some of that if you dig through that. But I'd also say that for those who support this transition to the MCLIS, one of the great factors is just what Judge Edmontaggio said, is that the restriction, some counties don't consider the probate judge authorized to obligate the county to funds. I, in fact, engaged in that conversation with my previous county administrator, who was a member of appropriations for years. And I think legally the county probate judge can commit the county to certain expenditures. So this would clarify that. Even if this weren't to pass and it were to come up again, it is something that needs to be made note of, that's one of the reasons why the appointments have to be shoved over to indigent legal services, because there is a question and tension between the judges, at least in some counties, and the county commissioners about the judge's ability to obligate the county to certain funds and expenditures. And I've taken the expansive view, and hopefully the law court will back me up if it ever gets to that point.
Thank you very much. Let's move on to the guardians ad litem and the visitors and see if there's any discussion or, well, actually, before we do that, are there any suggested changes or modifications to the provision in the transition plan for the court appointed attorneys? Go ahead, Justice Corman.
So just to address Judge Crockett's point, perhaps we should say constitutionally or statutorily allowed counsel as opposed to required, because as Janet correctly pointed out, there are some places where it says shall and some say may.
Thank you. That's helpful. Is everybody comfortable with that change? Great. Okay. Anything else on the court appointed attorneys?
Yeah.
Yes.
Totally off subject, but I just wanted to know that, last time we talked about the money part of when we were talking with Andros, there was a calculation mistake that's pretty big on court-appointed attorneys. And I'm not sure, and visitors too, about the cases that they are required on. It's not all the cases. And that really made the number go way down. So I just wanted to make sure that gets corrected in the final tabs.
Thank you. I think that's noted in the report, and it also would be subject to a much more granular analysis by OFPR. But yeah, thank you for raising that. Judge Crockett, is your hand residual or new? And Janet, I think yours is residual as well. Okay. Justice Gorman? Nope. Okay. All right, so we'll move on from the court-appointed attorney to the guardians ad litem and visitors. And this is, the provision here is a little bit different. So when a state probate judge appoints a guardian ad litem or a visitor who will not be paid by the parties, the judicial branch is responsible for the fees. And similarly, if a county probate judge appoints a guardian ad litem or a visitor, then the county would be responsible for those fees to the same extent that it exists under current law. And that once the system had been fully implemented, only the main judicial branch will bear responsibility for paying the guardian ad litem and visitor fees appointed in probate matters. So that is the proposal for guardians ad litem and visitors. Judge Crockett, go ahead.
Yeah, just something you want to address is when a case gets transferred between a county judge in this transition to a state judge, what happens is if it gets transferred on conflict for the judge, the county that the GAL has appointed, like let's say I had an issue and I had to transfer this to York County, but it was not based on the parties moving to the county, but based on my own conflict. Like it turns out my partner had represented somebody or whatever, then my county will bear the cost. If it goes to a state court based on the fact the parties have moved from Rumford to Portland, and Portland's now a state court, then the state will should pick up the expense of that appointment of the GAL. It shouldn't be on the county that it came from. So there has to be a distinction drawn, because that's the way it currently works. If I have a GAL appointed and I have to transfer the case because of a problem that arises because of my personal involvement, then our county pays the expense. If it's a geographic move, then the parties have to do it. Okay, so I just want to make sure it gets addressed in the technical drafting, because otherwise it's going to be a problem down the road.
Yeah, thank you for raising that. I had no idea that was an issue. Justice Gorman, did you want to weigh in on that as well?
Well, I guess we don't do billings at the end of a case. We do billings as a case is going on. So it seems to me that at least, again, I'm getting into the weeds here, but at least in some cases, there'll be some portion of the bill paid by the county before it's transferred to the state.
Thank you. Okay, I feel like those more granular details can be worked out in proposed legislation, and maybe we don't need to, Barbara and I need to be aware of that issue. I don't think we need to resolve it for purposes of the report. And thank you, everyone, for raising those concerns. So we've kind of talked about both of these, the funding for these court-appointed professionals. Is there anything else by way of implementation that we have not spoken about that we need to incorporate into the transition plan? I'm not, go ahead, Justice Gorman.
The only thing, and I don't know if this is in the weeds or not, but for the regions where there's an immediate state takeover, I'll just talk about Region 1, Cumberland County. There would have to be an immediate conversation with the county officials about the use of county facilities. In the Cumberland County Courthouse, for example, there's a separate probate suite. We would want the state judge to be able to use that and use the courtroom. And so we would have to begin immediate conversations with county officials about the use of what are currently county facilities.
Yeah, and so do we need a mechanism that is part of the implementation plan? would we need
Well, I think-
language directing or the judicial branch to engage in those conversations?
Well,
What
I
would be the
think,
fix?
I think one of the rationales for getting the facilities person in the JB immediately is that that could be his or her job to start the conversations with the county's commissioners about the use of sharing of what are currently county facilities.
Okay, and so we had actually, backtracking a tiny bit, we had talked about the IT person starting as soon as the legislation went into effect. And so we should also consider the facilities manager person
Yeah, I think so.
coming on board as soon as the legislation goes into effect. Okay, so that's a little bit of a modification. Thank you. Other concerns that need to be addressed in the implementation plan? Judge Crockett?
So the probate judge's authority to direct sheriffs, is that being touched at all in proposed legislation or no? Like, we have certain authorities under the statute because I guess it's always existed because we're county and their county. Is that being touched or not touched? And it doesn't matter to me. I'm just throwing it up there to make sure this is one of those things that's going to come out at a hearing. And if you don't have an answer, it'll obviously be an issue. So it doesn't matter to me either way, but.
I missed the beginning of your first sentence. Could you just restate that little bit of it, please?
So under Title IV, probate judges are able to direct certain activities of the sheriff. Example, when I did an emergency guardianship where a child was with a father, it was interesting situation. I could direct the sheriff under the title to go and deliver the emergency guardianship order to the father, and the guardian took the child at that time. Is that going to change under the new situation or not?
Go ahead.
Do you have a site?
I would
Yeah,
say
it's-
no, because the state court judges have that, or they can direct service and things like that as well. And I think as long as that's part of your judicial function to be able to do that. And it certainly wasn't my intention to strip the probate court judges of any ability to carry out their judicial functions for the time that they're serving in office.
Okay. Good.
Thank you both for raising that issue. Anything else on that issue? Okay, I think we've covered the transition plan, and it's 2:00 now. Let's see, I need a moment to consult with Representative Cardone here. Hang on a second, everybody. Okay, so we've talked about, and I've tried to summarize our decision-making process on the implementation plan. And I'd like to know from commission members if the plan that we've been working on is acceptable to you, and will get your support. And I know that Judge Crockett, you will have a different perspective on this. And you'll be submitting your minority report. But among those who are inclined to support the majority report, is the implementation plan that we've been discussing acceptable to you? We probably would fold the official vote on it into the vote on the report. I'm not seeing any reactions. We also need to take a bathroom break. I am aware of that. So let's take the break, and when we come back, we'll ask for final final positions on the implementation plan. So let's return at 2:15, everyone. Thank you. Hello, everybody. Good afternoon again. We're ready to get going. And once everybody has rejoined, I'll summarize where we're headed for our last 2 hours and a bit of our time together. I know that was a short break, and we'll just give everybody another minute to come back, including myself. Activate my camera. Okay. Thanks, everyone. So we have gone over the implementation plan. We still have our report to review, but at this point, a couple of procedural things. I would like us to have any final comments on the implementation plan. And then I would suggest that we proceed with taking a vote to reaffirm our decision on the plan that we had discussed earlier and voted on in our November 15th meeting, with the inclusion of the implementation plan. So that would actually be, I believe, a part 4 of the plan. Is that right, Janet? I know, it's fun. It's like I've so many pieces of paper here.
It is part 4 unless you include the long-term goal as part.
Okay, so since neither Janet nor I could remember how many parts there are, I'm just going to summarize it for everyone, because I think if we're all starting fresh after our break with a summary of the report and then adding on the implementation plan, that'll be the easiest way to go. So the plan that we voted on November 15th had actually 5 sections: a very brief statement of the long-term goal, recommending fully incorporating the probate court system into the judicial branch. The second part was the recommendations with regard to the judges, which would involve bringing the judges into the judicial branch as full-time state court judges in a special probate court within the judicial branch. The second part, the third part is the registry recommendation that has to do with preserving the system of county registers of probate as elected county registers and staff that remain employees of the counties. The fourth part the third part deals with the court-appointed professionals, recommending that the Maine Commission on Indigent Legal Services establish and qualifications and see to training, and that the judicial branch would establish requirements as well, and that the state would pay the costs of the attorneys appointed through the Maine Commission on Indigent Legal Services, and ultimately, although not during the transition, pay for court-appointed guardians ad litem and visitors as well. And then the final recommendation is the 3-year review with the specific items that we enumerated again on November 15th. So that brings us, that was our work and the vote that we took on November 15th. And then we would add to that the implementation plan that we've been discussing this afternoon. Janet, go ahead.
As you said that, it reminded me that one thing mentioned in the report draft is we were not certain of the timing of the 3-year review. 3 years from what?
Thank you. Yeah. So the question Janet raised is a need to be more specific with regard to when the 3-year review would happen. And so I will just make a suggestion that the 3-year review could happen beginning on January 1, 2028. So that would be 3 years after the full 9 judges have been appointed to the state probate court. Does that, I'll ask you first, Co-Chair Representative Cardone, does that seem like the appropriate time frame for the 3-year review?
That might be too long. I know the first, if we did it from 2023, I know the first 2 years are going to be difficult and might not be representative of what it would be afterward. But if we waited it, it just strikes me as too long. Maybe we do a 2-year review from 2020 from 2025. I don't know. 2028 just strikes me as too long.
So commission members, if we did a 2-year review that commences 2 years following the appointment, the final appointment of all 9 judges, that would be the review process would begin January 1, 2027. Does that seem like the right time frame to commission members? I'm seeing lots of nodding heads. Is there anybody who is concerned that that's not a good time frame? I'm not seeing any signals of alert and alarm. So we'll go with that. And maybe what we should do is that we should specify that the review will commence on January 1, 2027 and be completed by the end of 2027. Is that, Janet, is that an acceptable way to specify? Okay, we just got the thumbs up from Janet.
Yes, that helps for clarity for whoever, I can't imagine who might have to draft this legislation.
Okay, thank you. All right, so everybody's good with that decision? Looks like it. Great, okay. All right, and so at this point, I would request from you, Representative Cardone, we'll have a motion to reaffirm the plan that we voted on November 15th with the addition of the transition plan that we've been discussing today. Once we have the motion in a second, we will have more discussion. So I don't want people to think that we're forgoing any additional discussion at this point.
Will so moved do it?
Yes,
So moved.
thank you. And is there a second? Seconded by Justice Gorman. And so now let's have discussion on the motion. And you can address either the work that we did and the vote we took on November 15th and or the transition plan. I'm not seeing anyone raising their hand for discussion. Okay. Well, I would just like to thank everybody for the great contributions on the implementation plan, because that was something that was really hard to get our arms around. And I felt like we sort of got something on paper, but it was not nearly as robust and feasible as what we've done together as a commission today. So I'm just grateful for all of the contributions that everyone made to bring us to a better place on that. Any other discussion? Okay, let's move to a vote. And I will do a roll call vote, and just going to go down the list of members as I have them here. And again, want to remind those who are present and those who may be checking in later that the voting on this motion will be open until 5 o'clock tomorrow, December 1st, 5 o'clock in the afternoon. And thereafter, we won't be able to reopen the voting. And so I'll start with you, Representative Cardone.
Yes.
Representative Keim, Senator Keim is absent. Representative Sheehan. And she is also absent. Representative Hagan. Absent. Justice Gorman. Yes. Actually, could you please, I think you have to vote verbally.
Yes.
Thank you
Yes.
so much. Judge Martin. He is absent. Catherine Wiltuck,
Yes.
Judge Crockett,
No, but with the utmost respect.
thank you. Register Ayers,
Yes.
Julie Howard. She is absent. Judge Avantagio,
Yes.
Judge Mitchell,
Yes.
Tudor Goldsmith,
Yes.
Leo Delicata,
Yes.
and I am also a yes. And I'm just going to quickly look at the screen to see if anyone who was absent has been able to rejoin us. So give me a moment here. Okay, I'm not seeing anyone either. And Janet, will you be emailing an email to the commission as a whole, reminding people of the opportunity to vote?
Yes, like last time, although people who weren't absent don't realize we did this, we summarized what the contents were of the vote and then told people to register their vote by email by 5 p.m.
Thank you. Thank you. Okay, so everyone will have that reminder and the opportunity to vote. Okay, well, thank you, everyone. And now we will move on to the last step, and this is kind of from, before we do that, I did want to note that Judge Crockett is going to provide us with his report, which will be attached as an appendix. And then Senator Keim also sent an email with her thoughts about the recommendation. And we will allow, accept her email as well, unless she wants to make it a separate document. But in any case, we will attach her report as well to the report. And so that brings us to the report. And I'll just start with a little bit of introductory information about it and then turn it over to Janet. But from my understanding, and I have not been on one of these commissions before, but that often commissions don't get to the point of having time to work on a report as we do. And so it's a little unusual to have a report to look at. We won't in the next 2.5 hours be able to go through it with a fine-tooth comb. But what I thought we could do is have Janet summarize the report for us. And then I know that there are some sections of the report that some of us have some concerns about. And we can take the time today to express concerns about those particular aspects of the draft report and address them. And then at Representative Cardona and I would like to ask your permission to go over the final version of the report that our analysts prepare and make any, it will be non-substantive changes. It will just be small edits to make sure that the work of the commission is accurately captured. And so we would like your permission as a group to be able to do that. And Janet has her hand raised. Go ahead, Janet.
I would like to propose a slight alternative, possibly because I misled you in what I just said to you, Senator Carney.
Okay, you also know a lot more about this process than I do, so go ahead.
Okay, so traditionally what happens is, you're right, a lot of times the draft isn't seen at the last meeting, although it has happened before. But as you know, the draft isn't complete. So we will have to put in information about today and write up the transition plan. And traditionally what happens, whether there's been a report circulated or not before the final meeting, is after the final meeting, when there is a final, full, complete draft. It is emailed out to commission members, but their review has to be very curtailed because of Freedom of Access Act purposes. A commission meeting cannot be conducted over email. So if someone were to say, you know what, now that I see it in writing, I actually think a 3-year review is better than a 2-year review. We really went the wrong way. That's not something that can be fixed over email. But if someone says, oh, geez, Janet, you did it again. You wrote 2024 when you meant 2025. And that's what we all agreed on. That's a non-substantive change. That's just fixing an error that we've made, or maybe we omitted to mention visitors and we just wrote guardians ad litem. That's fixing an omission as well. So kind of errors and omissions can be fixed, but someone has to make the call on whether that truly was an error or omission. So oftentimes a commission will authorize the chairs to decide that that was in fact an error or an omission, and they get the final sign off on making the change. Does that make more sense?
Thank you. That does. Are there questions about the process? Go ahead, Judge Mitchell.
Thank you. It really is a process question. This reads like the minutes of all of our meetings, which are already attached to our website, et cetera. I just wonder if the report would be stronger if we just sort of said what we had done. I don't know. It feels like it's repeating what's already given to people, but I don't know. I don't recall reports just being minutes. I mean, it's more than that, but it's primarily minutes of our meetings, isn't it? Have I misread it? I mean, we have reports of what we sort of summarize what so-and-so said, and each person, and Judge Morton said this, Kathy Ayers said that. It's just a question in terms of, I haven't looked at a legislative report for a while, and it's a process question. Is that what they look like these days?
Let's let Janet answer that. Go ahead, Janet.
It is very lengthy, and it does read originally as minutes. So I'm very, very glad you brought that up, Judge Mitchell. There is a variety. So I had about 10 reports from the past open on my desk and looked, and some literally just said the commission heard from these 4 people. The second meeting, the commission heard from these 5 people. Boom, here are the recommendations. Others specifically said that the commission members asked for minutes to be included, so they were. There was a bit of a discussion there about how that made it really long, but it was kind of an interesting draft. I'm not going to name names of who wrote that one, but so there is a variety that could be done. We actually did try and take a completely more straightforward approach. We did want to just say the commission heard from X, Y, and Z, but we actually don't have minutes of any meetings posted on the website. We didn't make minutes of any meeting. And so what we did was we had to summarize the presentations. And the reason we did that is because Register Ayers was very nice and she gave a handout, but nobody else who made a presentation gave any materials. So it would just say that a presentation was received. And unless somebody goes back and watches the YouTube, which we have hyperlinked throughout the report for every single meeting, if they don't want to sit and watch the 10 a.m. to 5 p.m. YouTubes, then they won't have any information on what that presentation consisted of. So we summarized only presentations. We did put a note in there that we were not making any attempt to summarize any discussion by the commission members. And we did that for several reasons. One of which is people's positions evolve over time, and maybe they don't want the report to say, you know, on the first day I thought this, when maybe on the last day they didn't think that anymore, and they would prefer just not to get into that. Other times it is because, as we've mentioned in the past, sometimes what we hear as staff is not really what you're saying. And we would not at all want to mischaracterize any of that. So what we did was we did summarize the presentation. The problem is that some of them were so long that it really does look like we took minutes. And I don't know how that reads to you. It's a great point, because everybody who presented gets a lot of pages in the report, and everybody on the commission gets no pages other than the recommendation section, because we didn't summarize discussions.
Justice Gorman.
So I guess this is a follow-up on Judge Mitchell's question, and this really is directed to the legislators in the room. What's more effective? Having a 21-page document that goes through in very, very good detail what occurred at the meetings, or a robust but short report that explains what our recommendation is, and then save for a question and answer period or a presentation to the Judiciary Committee the things that we considered if questions are raised. My fear is that by putting everything in here, what we're doing is actually creating more possible loopholes for people to, or wormholes, whatever you want to call them, for people to dive into and find problems with. Because as Janet just pointed out, I think we have used this process very well in terms of really talking through, changing our minds, being willing to listen and consider other ideas. And we have come to a consensus opinion as to what should happen. And I think, but again, I'm not a legislator, never have been, hope to God never will be. There may be a better way to present this that I am not aware of. Maybe having all of this is actually more useful to you. So I guess I'm asking for help from the legislators. What's more useful?
Yeah, that's an excellent question and a good perspective to view it from. Go ahead, Representative Cardone.
My opinion is that most people won't read the full report. They'll read the executive summary. If they read anything at all, they'll read the executive summary. So the executive summary really does need to be boosted up and get our a very distilled version of what we want to say done. The report itself, for those who want to wade through it, does have final, does provide some heft to the work that we did. You can argue either way that, well, why are we going to write this thing that nobody reads it? But at least for the people who say, well, you didn't do anything, or what did you do? You can say, yeah, here we did, and it's contained in these 58 pages or however long it is. So I personally don't mind going into detail, especially where we don't have minutes. I don't mind going into the detail as long as we have a very distilled, specific executive summary.
Yeah, and I think I might fall on the opposite side of that equation as you, Representative Cardone, because I do think that having a really short, concise report that sort of outlines the steps we took and then focuses immediately on the recommendations is probably going to be more likely to be read and grasped by people who are juggling a lot of different things in preparation for a committee meeting. But I also think that the work that Janet and Sam did summarizing each meeting was incredibly valuable and reflects all of the hard work that we did. And I wonder if it's possible to do kind of what Judge Mitchell suggested of having like something akin to minutes for each meeting, maybe like a summary of each meeting posted on the website, and shift that content out of the report and just have the report be the roadmap of where we're going in the future. So that would be my thought. Jen, is that something that's doable?
I balk at the word minutes because we did not summarize what you all said. We can do that, but I have the same reservations that I had before. There are two alternatives, is just have summaries prepared by staff clearly stating so of the presentations given, either on the web or stick them in the appendix, just like Register Heirs, who provided that lovely handout we could refer to in the appendix. Would just be referred to the summary of that presentation in the appendix. But if that makes it too long, that could also go on the website as well, whichever you think is more persuasive for your purposes, because our job is not to persuade. So,
Okay. Yeah, so we wouldn't call them minutes. We would call it a summary of the first meeting, a summary of the second meeting. There are other hands up. Judge Mitchell, is your hand up anew or?
It is anew.
Go ahead.
It's been a long time since I've been a legislator. On the other hand, decision-making in business or in memorandums of law or in anything else are powerfully made by a good executive summary up front. And so everybody's busy. I think this executive summary needs to have more punch. This is what has just happened with these 4 meetings is monumental. It is transformational, and we need to own it and put it out there, and then attach those other things as summaries. I won't use the word minutes, but make it shine. And there are people who will read it, and those who want to read the rest can still do so. We're not hiding anything, but you really need to get people's attention. As I said, this is transformational, and we need to let it shine out. And this doesn't do that for me.
Thank you. Leo Delicata, go ahead. But we're not able to hear you.
Thank you. I agree that an executive summary is important and really is the product that legislators, if they read anything, are going to read. I am concerned, and I'll just build a bit on what Judge Mitchell said. I'm concerned with preserving the historical nature of what we're doing and what we've done. I think it was very important to be able to read the proceedings of other commissions. I think that reading the Futures Commission report, which was very, very lengthy, was important in terms of giving a perspective about where the court was in the history of the court. And so I'm really encouraging us to have something other than or in addition to an executive report that can be preserved for historical purposes. Now, I'm happy that we have a website. I'm happy that things are being preserved on a website. I don't, given how technology works and given the fact that I'm still using pencils, I like the idea of having something that can go into an archive and be read in the future. So whether it goes on the website or not, I still think we ought to have a product that ends up on paper or ends up on some medium that can be archived and preserved and read later on by other people who may follow us. And I'm thinking in particular people that may follow us, when the review commission starts looking at what has transpired. So I don't think that what Janet has written should be lost. On the other hand, I also think that we ought to have a product that the legislature can use, and being acutely aware of the time problems that red legislators have. Even if they're willing to read long documents, they may not have the resources or the time to do it. So short executive summary, everybody can read, and a longer document that can be preserved for historical purposes would be my vote.
Thank you. Commission members, are there other comments on the look and feel of the report? Okay, I am not seeing any, so I think we have to make a decision. Janet is nodding her head. Representative Cardone, what's your, you've been listening carefully to the comments. What's your inclination?
I'm thinking both that I agree with Leo Delicata about preservation. And I found when we started this process and I went back and looked over all of those reports, I found the detail very helpful. On the other hand, Judge Mitchell has read more more legislative reports in her career than I ever hope to have to look at. She's concerned that it's too lengthy and too detailed. And I think if I'm understanding you, Judge Mitchell, you think it needs to be more to the point, more scaled down. In particular with the executive summary, we agree on that. So I can't make up my mind. I do think we need to preserve the details somehow. If it's in the body of the report or if it's somewhere else, I'm okay. But I do think what they've written needs to be preserved.
Janet, is it feasible to include the summaries of each of our 4 meetings as appendices?
So we could do that, or we can make a very brief summary that says they heard from these 3 people and see Appendix A for the summary of so-and-so's presentation, see Appendix B for Kathy Ayer's handout, another plug for that lovely handout, see Appendix C for summary of the other person's presentation. And so it will say in the body, you heard from these people, but it won't drag on and on and on. And that's talking about my own writing, so I couldn't do that.
Well, I don't agree with you about dragging on and on and on, because everything you wrote is really incredibly well written and important and interesting and should be preserved. I think we all agree with that. But I think that latter suggestion that you had about referring to who spoke and then referring readers to the appendices is probably a good approach. Judge Mitchell, your hand is up. Did you want to weigh in on that?
Just very briefly, I don't think this is mutually exclusive. I think we can do both, preserve the written summaries, which are so well done for the historical context, but then just have this really strong executive summary. I just don't think that one excludes the other.
Thank you. Commission members, is everyone comfortable with the second approach that Janet outlined of having a brief summary of who spoke at each one of our meetings and then referring in that brief summary to the appendices that have the more detailed presentations and summaries? Is that okay with everybody? I'm seeing some nodding heads. Okay. Then I think, well, Janet, thank you so much. That we'll go with. Thank you, Sam. Janet's saying that it was Sam's idea. Thank you, team, for the suggestion, and we will go with that approach for the report. And let's see. I did want to give commission members, because I know that there were some aspects of the report that might have jumped out at people as being things that either should be highlighted or elaborated upon or eliminated. And I wanted to give everybody who had a concern about specific content in the report an opportunity to just give us a quick raise those issues so that we can address them in the next version of the report. And so I'd like to do that at this point. And then we will go through and we'll focus on what we want to add to the executive summary. So Judge Mitchell, I'm gonna call on you first, if you don't mind. And was there anything in the report that you were particularly concerned about that either needed to be eliminated or reworded?
I really just wanted to focus on this one thing for now. I just thought on the first page, I think under the introduction in the last sentence of that second paragraph, in addition, as the only elected judges in the state, and then it goes on about whether or not we're subject to the Code of Judicial Conduct. I just think that that's incomplete. There are carve-outs when we are allowed to campaign, but at the same time, that's a window of time. It just needs to be clarified. I think that's a little misleading. It acts like we're vigilante judges.
Yeah, I think that Janet, did you have a suggestion for changing the language, or Judge Mitchell, did you want to suggest changing the languages?
Alas, I have not focused on changing the language. I was frantically.
I have a suggestion
Good.
then, because I think what the gist of what you're saying is that there are limited exemptions from the main code of judicial conduct, rather than it saying that they're exempt. Would that capture it? And Justice Gorman, you can volunteer because you may have some wordsmithing as well.
Well, I would actually take out the last two sentences because as we've discussed, although there has always been the concern about a conflict of interest and a concern about problems, we haven't seen them. So it's not necessary to say that the judges are not bound by any portion of the judicial canons, because with the exception of one notable former judge, there haven't been problems with the probate judges and the canons. And so that we don't need to say that there have been problems that are pushing this forward. What we need to say is that we want all judges to be full-time, and the system that we're choosing for that allows for it.
Thank you, Justice Gorman. That certainly answers my concerns. And it also goes to Kathy Ayer's initial guidance, which was to focus on the positive and what we're trying to accomplish.
Go ahead, Representative Cardone.
The only concern I have with that, or I think that the reason that those two sentences were included is that the resolve does talk about, which you can see on the next page, promote judicial responsibility and adherence to the main code of judicial conduct. And to change the structure of elected judges, I think, is in keeping with our resolve to bring the probate judges closer to the adherence of the Code of Judicial Conduct that all of the other that appointed judges are required to follow. That's not to say they're doing anything wrong now. It's the system that is allowing for these elected and part-time judges. But by getting rid of those exemptions, we're following the resolve. That was my reading of that.
So respectfully, the canons create a carve out because we have elected judges. As soon as we no longer have elected judges, the canons will be fixed. But I fear that this really creates the impression that we're doing this because we have bad elected judges, and that is not why we're doing this.
And I don't want to suggest that is the case. Okay, I mean, if people feel that that's what that sentence conveys, then I would agree that it shouldn't be in for those sentences.
I'm the subject of it. I have a hard time reading it and not feel like it implies a problem that doesn't exist.
Okay. Yeah, I would be more comfortable taking it out as well. Taking those two sentences out. Everybody okay with that? Is there anybody who wishes to keep them in? Okay. Does anybody else have suggestions of things that they are concerned about in the existing language of the report? Again, knowing that the format will change a little bit. Excuse me. Just going to take a moment because I had made some notes and I just want to double check them before we move on. This is a very small thing, but at the top of page 615, there's a reference to the sentiments raised by public commentators. And I just wonder if the word concerns or items might be a little, when I think of sentiments, and maybe it's my legislative hat, I think of legislative sentiments. Thank you. Is everybody okay with that change?
Yeah, I am. I think the word sentiment was probably used to distinguish it from a factual statement. But I don't want to I don't want to convey that these were facts, that these were something different.
Okay. Anything else from commission members? Okay, let's turn our attention to the executive summary. I know that some commission members had suggested that it be beefed up a little bit, and we don't need to go into specific wordsmithing, but as far as the content, what are the additions to the executive summary that we think would be helpful to legislators and actually to others who are reading this executive summary and record of our work? Go ahead, Representative.
I think we need to put the goals in that we listed. Not necessarily the reasons for the goals, but these were the goals. And then these are the steps we're going to take to achieve the goals. That's how I would write it if I was going to sit down to write it.
You want to reiterate what those goals were for us? I know we've all got a ton of paperwork floating around on our desks.
Well, they're later on here.
I put you on the spot. I'm sorry.
That's fine. Under under number 3, recommendations. I think we need to we need to enumerate all of those. Now, there was some discussion about.
What page are you on?
Oh, I'm sorry, I'm on page 21 of the preliminary draft.
Thank you.
There was some discussion about whether A should be D or E, I guess. And I'm wondering whether we shorten those a little bit or not.
Shorten the recommendations.
Shorten the recommendations for the executive summary. I'd really have to go through and look at them. Some of them are fairly detailed. So I might shorten those, but I'd add the recommendations, and then I'd need to put at least in a summary version, the transition plan in the executive summary as well.
Yeah, so that's the highlighted section on page 2 where the executive summary is, the reference to including the final language of the recommendations. Okay. And so you're envisioning a summary of the recommendations in the executive summary?
I think so.
Okay.
I mean, again, I'm assuming that the executive summary is all that most people are going to read. And so I think they should have our recommendations and what we want to do and how we're going to get there.
Okay. And let's, Justice Gorman and Judge Mitchell, do you want to weigh in as well?
Yes, I agree with Representative Cardone. I think frankly, what's now drafted as sort of the summary of the fourth meeting needs to be moved up, so it's part of the executive summary. And the other suggestion I'm going to make is that the first recommendation, which is the commission recommends a long-term goal of fully incorporating the probate court system into the state judicial branch. I think we end it there. And then we talk about this as a staged event, as opposed to a fallback position. Because I think as we talked about it today, we realize the benefits of having this occur in stages. The training opportunities, the data collection opportunities, it will be messy, but just because it's messy doesn't mean it's not the better way to do it. It would also allow for a much better way, an opportunity for us to figure out how to either convince the Kathy Ayers of the world to come and work for the judicial branch, or how to clone someone or get them trained by Kathy Ayers so we can actually incorporate that kind of good work into the state court system. So, I mean, we've been thinking about this as a Band-Aid when we actually need a bandage, but maybe we should be presenting this as a better step-by-step way to get to where we want to go. Be more positive about it.
Thank you. Judge Mitchell?
I agree with Justice Gorman 100%, 1,000%. We should be about the last meeting, not how we got there. This is a tedious journey. Say I'm sitting on the education committee or on the legal, what I don't even know what it's called anymore. Let's say conservation and forestry. I don't know what you're talking about here. Why is this important? We didn't even mention that for 50 years we've been trying to get it done, but that's not even the most important thing. The most important thing, we are creating a better system to serve the citizens of Maine. Make people excited about it. Make them want to do this, because there will be state judges. There will be whatever the words are you think that pulls this together. I'm not a good wordsmith, but I see that this just reads, again, more like a summary of minutes. It doesn't. Does this inspire you to read the resolve? It doesn't inspire me. So inspire us, and also flip what we're doing, and just give people who are reading only this page, or 2 or 3, if you could make the executive summary into that, they want to read more. Let them want to go read the rest of it. That's pretty cool what they've done, but why did they do it? I don't know from looking at this draft, and I'm not criticizing the draft because that's what we asked them to do. But can't we make it so that it invites people to want to know more, because it's a huge improvement in the justice system? I'm thinking that that's what would appeal to me as a member of another committee who had to figure this out. Even the Judiciary Committee didn't have the honor of sitting through 4 meetings with us to get this level of detail. And I think the consensus building was key, because we all learned from one another and did evolve and change. And you have to somehow bring other people there who didn't have the benefit of these 4 meetings. And I know we can do it. The wordsmith, at least among probate judges, because Justice Gorman was our liaison forever, and she does it on Flack as well. If you need wordsmithing, she's your person. But I suspect that both our chairs can do the same. So that's all I wanted to say. I still want to get some excitement. I want to pump it up so that people are going to be intrigued by it and think, oh God, not another study. Thanks.
Thank you. Commission members, are there other comments on the executive summary or the report in general? Justice, go ahead. First, hang on a second, Leo Delicata, Justice Corbett. Okay, you're all set. Okay, go ahead, Leo.
I just wanted to second what Judge Mitchell just said. I'm not exactly sure how we're exactly going to get there. The creation of an exciting piece of writing that masquerades as an executive summary is a pretty hard thing to do. But and maybe that's why there ought to be a draft sent around, and we ought to look at it. And if people had suggestions as to how to, make it more exciting or readable or whatever, we could make them. I'm not sure. Honestly, I don't know how to do this. I'm just agreeing with Judge Mitchell, and I don't know exactly how to get there, but I'm sure it can be done.
Yeah, and I think that the end product can be done. We cannot use the process of emailing around a draft and having people comment on it because of the public meeting requirement. But I think that we've had comments that help us point us in the right direction for the draft. And commission, are there other commission members who wanted to weigh in on the look and feel and content of the executive summary? Justice Gorman, go ahead.
So I have a process question, and it goes to what Leo just said. I understand that we can't comment by email in the way that the law court comments with each other's on its draft. Would it be possible for us to create a public Google Doc and comment on that so that the public can see the making of the sausage? That might be just too transparent. Or would it be possible for us to have another short meeting after we've had a chance to look at the draft and come back at that point? Because I fear that given the direction that we're suggesting that Janet and Sam take now, it's going to be a substantially changed document. And I don't know how we can say yes to it when we won't have had a chance to really look at it.
Thank you.
And that's a process question, and I don't know how that works.
Yeah, and I think that Janet may want to respond to it. Just a
So I
moment.
have been here a while, but not that long. And the studies I've worked on, and every study report that I looked at, except for one or two, the executive summaries are sort of a rote. They're just sort of way about them. I've seen one or two that are slightly different. And Sam and I don't normally write in an advocacy way. I mean, we're capable of it, but we're not usually allowed to do that. So it's a little awkward. So I have emailed people in our office who are more experienced to get their input. I think Peggy said it might be able to work. I haven't heard back from others, and we've contacted the director who is sick today, so we don't expect to hear from her right away. So that's just a background of saying it's an odd position for us to be in to write an advocacy piece. I'm not saying we're incapable of it. I think we can write advocacy. We're trained lawyers. But if it makes people more comfortable, and it may not, the chairs could write sort of a forward of an advocacy piece, or if we get the direction from our staff, absolutely go ahead and advocate away. It seems a little odd where it's a divided report, but that doesn't mean we can't do it. I just don't know the answer to that question. Does that make sense?
Yeah, it does.
To follow up, there was a suggestion of another meeting, and I do think that we have a problem with that. I don't know if we can get where the resolve said 4 meetings. And I don't know what we'd have to go through to get a 5th, if we can even do that. And then there was a question about using a Google Doc. And I know that has come up, the possibility of Google Docs has come up before with committee hearings and the like, and there were problems with that, but I can't articulate exactly what the problems were and why we're not supposed to be able to do them. And I don't know if you can address either of those points, Janet.
I don't have any experience with the Google Doc. I'm not in the Judiciary Committee normally, so I don't know if that would count as a public meeting. It doesn't sound like a public meeting to me, and you are supposed to conduct public meetings, but it may be that it does. I just don't have the expertise under FOA and the right to know laws. But as far as having another meeting, you can request permission from the Legislative Council, just like you requested permission to have the report extended to the 15th. And they will do that by ballot. You don't need them to have a meeting between now and then. So it's not that you can't get an answer if there isn't a meeting scheduled. So that's fine. It's whether you can get a quorum and talk about it. And so from our director, we just have a short text back and forth, so it's not a full conversation that we've been able to have with her. But we would need, if you want us to write it in an advocacy way, we would need very clear guidance on how to advocate and how to write it from you all now in the meeting. Just because it's not normally what we do. So I'll just give an example that hopefully doesn't make everybody upset. But remember when we talked about the rationale document, the reason that arose is because we knew what your recommendations were, but we didn't know what you wanted to write down for why. And we suspected what happened, which is not everybody agreed with all of the different reasons that had been given in the past during meetings by other people, some of them public commenters and not even members of the commission, for why to recommend certain things. And so if we had selected just out of the blue what we thought were persuasive arguments to try and make it persuasive, we would have offended a lot of people. We suspected that was true. And in fact, it was true because not everybody agrees with all of the different reasons that have been given. So it's dangerous in that sense. We do have the reasons everybody's agreed to now, and we can highlight those and say, these are the recommendations and these were the reasons given. We can absolutely say that. I don't know. I don't think I'm being very articulate here. Or another alternative is if the members all feel comfortable with authorizing us to work with you both on how to make that executive summary persuasive. And if they're fine with that sign off, then we would work with you before the draft goes out to the commission by email. And then when it goes out by email, again, it would have to be that limited to errors, omissions, kind of very non-substantive changes. But you seem both like very persuasive individuals, so I'm sure you could help us make that persuasive in a way that maybe the members would be okay with, if they're okay with delegating that to you. Does that make sense?
Yeah, it does. And we've got a couple of hands up, and I just want people to think about, we'll hear comments from Tudor Goldsmith and Judge Mitchell, but think about whether you'd be comfortable delegating to Representative Cardone and I the responsibility of working on a more exciting advocacy type approach to the executive summary with Janet and Sam. And again, you'd have to kind of live with what we came up with, other than kind of technical changes. And so let's hear from those with hands raised. Just go across the screen, Judge Mitchell, and then Tudor Goldsmith, and then Leo Delicata.
I just want to clarify something. I realize OPLA is not to be advocates. I'm not asking anybody to be an advocate, but it started with Justice Gorman's attitude that we start with what happened today, which is a product, which is one to be pleased about. I'm just suggesting that you make it more interesting. And instead of just listing who's on the commission, what the resolve says, talk about why it's important. And if that's advocacy, so be it. But I'm obviously OPLA can't step outside its role as being a neutral drafter. And I also do trust the chairs to make the decisions. And I don't think we need another meeting to do so, because I think we're all expressing how strongly we feel about how the robust executive summary should be, not trying to put OPLA in a position of advocacy. I'm not even sure that's the right word. The advocates are going to be these chairs in the legislature. And so our job is to say, here's a product, and it's a good product, and starting with what it is. And this doesn't do that yet. And so I think you can make it robust without pulling Janet and Sam out of their comfort zone where they should stay. I'm not suggesting they did anything that they should not have done, but I think they can be free to be a little more exciting in their draftsmanship under the guidance of our chairs. Thank you.
Thank you. Tudor Goldsmith?
So I'm more of a doer than a thinker sometimes, and I don't know what our time constraints, how many other things we need to cover today we have, but I think we could probably do a screen share and a pretty down and dirty rough draft simply by copying and pasting some of the really well written stuff that's in the introduction just on the pages following the executive summary. I mean, there's the third full paragraph that starts in 1967. that gives a very brief history of the fact that there's a constitutional amendment out here that's pending that needs to be acted on, and it hasn't been acted on in decades, really half a century. And then, following that on page 4 of the same document, there are some bullet points. Obviously they might need some revision following our discussions today, but I would concur with everybody else that, the language that's in the executive summary seems like stuff that I'd rather see in a footnote if it has to be in there. I mean, I'm not a legislator. I have zero experience. Maybe this is how executive summaries need to begin, in which case, I retract my comment, but otherwise I'd say take all that out and just kind of take a lot of what's in the introduction, and we could probably get something pretty close to a rough draft done within a few minutes even.
Thank you for those comments. Leo, you want to, and we can't hear you.
Yeah, thanks. I don't expect that what's going to be written is what is traditionally thought of as an advocacy piece. I'm really looking for something that's simple, clear, and has a historical perspective and communicates not only the difficulty, but the enthusiasm and the hard work that we've done in getting to where we are. And there may very well be pieces of what's already been written that can be joined and made into an executive summary. I guess I just wanted to say that I trust the chairs to do this. And I think that whatever product they and Janet and Sam come up with will be exciting enough for me, and hopefully clear enough and easy enough to read by anybody, whether it's a member of the public or legislator. So I'm happy to delegate whatever my part is to them. And that's all I want to say.
Thank you. Other thoughts, comments to share? Tudor, I love your suggestion of doing a quick live Google Docs at this meeting. I'm not sure that we can do that. And I would, in lieu of that, ask that you all agree to let Representative Cardone and I work with Sam and Janet on the executive summary. And Tudor, I love your suggestions for how to begin it. I think they're really great. And I would just invite everybody to share other suggestions right now and have confidence that Barbara and I can work them into the executive summary. But I know that there are parts of the work we've done together that really jump out and are valuable to all of us. And I would just ask that you share them now so that I can take notes. I do think that the fact that this has been a constitutional amendment waiting to be activated for 50 plus years is a pretty gripping beginning.
Half a century.
Half century. I was 4 when it passed. I had a Snoopy lunchbox in kindergarten. Other thoughts? I won't refer to the Snoopy lunchbox, and we don't need it to be that exciting. Other suggestions of things that we should make sure that we add to the executive summary? Well, if you think of any between now and when we wrap up today, just let us know, please. did want to turn everybody's attention to the very end of the draft on page 23. There's an indication that we're going to add the transition plan, of course. And then there are a couple of other items that were listed as potential additions. One is a discussion of additional cost estimates that might need to be performed. And I'm not sure that it makes sense to include those because the OFPR process, the fiscal note process, is going to be so thorough and directly tied to the legislation as it's working its way through committee. Okay, so Representative Cardona and I are in agreement on that. Is that okay with everybody else to omit that? And then the last is an expression of the commission's gratitude for the members of the public and all of those who participated in this process and helped us with our work. And I'm assuming that everybody is on board with that. Leo? But we're not. You're muted. Yeah, we're not able to hear you. Thanks.
Yeah, you'd think I'd know by now. This is kind of an unusual request, but I mean, I've seen thanks to everybody in reports before, but I'm wondering if it wouldn't be appropriate for us to, empower the chairs to send a thank you note to everybody that actually presented before us. That was a lot of work to do. And getting a note from the commission, I think would be a nice keepsake for them to have. So that's my suggestion. Of course, anybody who's made a comment or sent in testimony or whatever also deserves a thank you for taking their time to do it. But especially those who actually made a presentation, I think deserve more than just a mention.
Thank you. That's a nice thought. I'm fine doing that. Yeah, sure. We'll do that if everybody's on board with it. Justice Gorman?
I was going to suggest something slightly different than what I think Leo's is a wonderful idea. I just wanted to make sure that in the expression of gratitude in the public report, we publicly acknowledge those people who came and presented, Judge Morton, Professor Smith, because they actually did the work and showed up. So I want them to be in the report. It's also lovely that they get a handwritten note from you or from Representative Cardone, but I think we also need to publicly acknowledge their presentations.
Thank you. We will do that as well. Anything else? Okay. Janet and Sam, what do you need from us in the last little bit of time we have?
I'll recap, and if you all agree, then I don't think we need any more, but I will let Sam jump in if I'm missing something. But I think we've been instructed to add the transition plan would be part of the recommendation, so it wouldn't be a separate section because you did in fact all vote on it. Aside on the voting, we will send out a summary. It will probably just be that transition plan A through E with an F. The recommendations A through E with an F. Tell the people who weren't here for the vote, that's what you have until 5 to vote on, just so that they know what they're actually voting on. I think that's helpful to them, so they don't have to listen to the whole YouTube. That would take up most of their 24 hours. But back to the report. So we will add an F as the transition plan. We will note the reasons that everyone agreed upon. It would just be very brief, sort of the reasons that people have agreed upon for that recommendation section. As far as the summary of this particular meeting, it would be very short because we are not including minutes of like what everybody said as the meeting went on. So there wouldn't be too much about this meeting in the report other than final votes were taken, etc. And then as far as the summaries of the meetings that are in there so far,
Since they are mostly about what presenters said, they will become very, very short. It will just be a bulleted list of who gave presentations and maybe that public comments were received, and then all of the summaries of those presentations and the summaries of the themes from public comments would appear as appendices. All the links already exist to the original documents, so that will help people as well. And then as far as the executive summary, the idea was not advocacy so much as pithy, interesting writing. And we have, I believe, the consensus of the members to run that language by the chairs and have their input on it before it goes out as the official final draft for email review. And I believe everyone understands the email review is non-substantive in nature. And I think people might feel a little better about that, knowing that you all as the chairs have the charge and are going to be able to help us fulfill what the commission just agreed upon. And because we have that officially now on the record, that makes me, and I believe Sam as well, feel much better that we can do what you want within the confines of our role, because we will have that permission to work with you and make sure it achieves the goals without necessarily needing another meeting. So I feel a lot better. Hopefully everybody else does too, but if all you care about is me, then great.
Thank you. Sam, did you have anything that you wanted to add to that? No, all set. Okay. Thank you both. That feels like a good direction to go. Commission members, is everybody satisfied with that process going forward? Any concerns about it? Okay, I'm not seeing any. Then I think our work may be done. Which is really nice. We had a tremendous assignment when we started, just 4 long meetings ago over a short period of time. And truly the end product that we have reached is immeasurably benefited by all of your hard work. Thank you. Judge Mitchell, and then I'll let Representative Cardone have the last word.
She deserves the last word, and that was what I wanted to say. Her perseverance in this issue is to be commended. We certainly wouldn't be where we are today had she not been so, what shall I say, persistent and courageous, and absolutely set on making something positive happen. And then you, Madam Chair, run an excellent meeting. The process is fair, you're inclusive. You also keep us on task when we wander away. So I just wanted to thank you very much for your leadership in chairing this commission.
And I wanted to thank all of you. I'm going to need even more perseverance. The easy part's over now. But honestly, I could not have delivered the sort of product that I want to deliver, and to be able to advocate for the sort of product that I want to be advocating for without the input of each of you. And I know many of you came to this this process with reservations. Many of you, they still have reservations, but I really believe that the input that we received from each of you has made this bill stronger. And I feel much more confident going forward with a product after we've had this process, than I did sitting down and trying to write a piece of legislation with just by myself, or with 2 or 3 other legislators. This has been a great process. In particular, I'd like to thank my co-chair, Senator Carney. I had the vision of what I wanted to do, or that I wanted to get this process started, but she carried this process through. Her skill at running a meeting and keeping discussions focused and staying with an agenda were just far beyond what I could have done, and dealing with Zoom were far beyond what I could have done. And the excellence of this product is due in large part to your skills at chairing this meeting. So I really want to thank you for that.
Thank you. I'm gonna turn the mic back over to you for a second, but I felt like the teamwork of your extraordinary subject matter expertise was such a huge part of what we were able to achieve, and I'm really grateful for your leadership. Thank you.
Beyond that, thank you all. Happy holidays. Stay tuned for a draft.
Thank you, everyone.
Bye-bye.